Good afternoon and welcome to the Tuesday, November the 7th, 2017 convening of the Baltimore City Board of Municipal and Zoning Appeals. A few house rules before we get started. First, if you have a cell phone, a pager, anything that makes any sort of audible, electronically generated sound, plays a ringtone, a chime, etc. We ask at a minimum that you please turn those devices to a vibrate only, if not off position. Similarly, to the extent that you need to have a conversation with someone, we ask that you please take those conversations out the double doors to your rear. And the reasons for those rules are pretty simple and straightforward. First, you'll note that there are a number of microphones which are arrayed around us up here, and those microphones are all very sensitive. They're not only for the purpose of amplification, but they're also for the purpose of recording these proceedings, and cell phones, pagers, conversations, and the like going off in the gallery or coming from the gallery interrupt not just the general conduct, but also the recording of these proceedings. In addition, those of you who are forward of the wall above you, if you turn around, you'll see that there are 1, 2, 3 video cameras which are mounted on the wall up there behind you. And there are 1, 2 video cameras which are mounted on the wall up here behind us. And these proceedings are being videotaped or recorded, I guess, for broadcast. They're being streamed live. You actually could pull it up on your phone now if you wanted to, on the city's cable access, the website for the city's cable access network. In addition, these proceedings are also being recorded for subsequent broadcast on that cable access network, and are being recorded for posterity on the city's YouTube channel. So cell phones, pagers, conversations, and the like also interrupt that process as well. You're certainly more than welcome to stick around and enjoy a civics lesson if you so choose. We will be voting at the end of the day, and if you have other commitments this afternoon, that's certainly understandable, and you can call into the zoning board office in the morning and find out how we ruled in your case. We will, however, first, if you take out pen and pencil, I can give you the number for the zoning board office, and I'll read this number off a couple of times. That number for the zoning board office is 410-396-4301. Again, that number is 410-396-4301. You will, however, need to wait until you receive the formal written notice of the outcome of your case, which should be forthcoming in about 3 to 4 weeks before you will be able to obtain your permits. And we certainly ask that you please not build in the city of Baltimore without first obtaining all of your proper permits. If you haven't already done so, if you're here in opposition to any case today, we ask that you please sign in on the sign-in sheet, which is being held up right now by Mr. French. The sign-in sheet generally allows us to know which cases have opposition. It also allows us to know who needs to receive those aforementioned written notices I just referred to. So in addition, we do have at least one case which is being postponed, and if you are here on any case that is being postponed, we need to know who you are and how to find you in order to send you the notice as to when those cases will be going forward, as they will not be going forward today. If the procedure for when the cases are called is the same today as it is for all of our hearing dates, those of you who are familiar with our proceedings are likely already familiar with that process, but for those of you who are unfamiliar with it, if you are the appellant and the case is called, you'll come forward and you'll stand to our left or your right. The opposition, if any, will come forward as well and stand to our right or your left. Once everyone is up here, we'll get you all sworn in, and we'll first begin with the appellant, who'll be given the opportunity to tell us what the issues are involved in the case, what it is that they're seeking, present any documents, witnesses, etc., that they would like to offer in support of their arguments and positions, and also respond to any questions which the board may have. Once they have completed their presentation, the opposition will get the opportunity to do the same, to present their documents, witnesses, etc., present their arguments to the board, and respond to any questions which the board may have. Once the opposition is concluded, we'll then turn back to the appellant, who given the opportunity to respond to any points that are brought up by the opposition, and then to offer a closing statement. We won't be going back and forth and necessarily delaying things longer than is necessary. We will generally be calling the cases in the order in which they appear on the docket after we first dispense with some preliminary issues. First, as I mentioned before, there is at least one case thus far which is being postponed. 2017-412, 1500 West Baltimore Street, Mario Camacho. That case is being postponed. It will not be heard today. If you are here in reference to that case, please make sure that you signed in on the sign-in sheet so that we can let you know when that case will be going forward, but that case is being postponed and will not be heard today. Next, we are going to take the cases on our consent agenda, and those cases consist of those matters where the board has reviewed the files in those matters, and the board has determined that we have the ability to approve these appeals on a consent basis based upon the record submitted thus far. We're going to call the consent cases together as a group. When we do, if you can please try to stay in the order in which you're called. But once everyone is up here, we'll get you all sworn in as a group, and then we'll call each case in turn. And as your case is called, at that point, you may offer any other information that you would like to have added to the record at that time. Consent cases are 2017-390, 1607 Webster Street, Jason Seeley.
Step forward.
Yes. After that will be 2017-406, 3642 Elm Avenue, Todd Newman. And finally, we'll have 2017-407, 2500 East Northern Parkway, Jessica Bingham. All right, if you can all raise your right hands to be sworn, please.
Do you all swear or affirm under the penalties of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief?
I do.
All right, calling the first case on the consent agenda, 2017-390, 1607 Webster Street, Jason Seeley.
Correct.
All right, Mr. Seeley, you can come forward to that microphone there, sir. We have this as an application to construct a rear deck at this location. Is that correct?
Correct.
All right. Mr. French, anything from the planning department regarding this appeal?
Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
All right. And Mr. Seeley, did you have anything that you would like to have added to the record at this time?
No, at this time, no.
All right. Zoning board staff, having previously reviewed your application, you've determined that there is sufficient information to approve your appeal. Good luck.
Great, thank you.
Yes. 2017-406, 3642 Elm Avenue, Todd Newman.
How you doing?
Afternoon, Mr. Newman. We have this as an application to construct a second-floor overhanging rear addition at this location. Is that correct?
That's correct.
All right. Mr. French, anything with regard to this application?
Planning Department has no comment on this application. Thank you.
And Mr. Newman, is there anything further you would like to add to supplement the record in your case?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Next, 2017-407, 2500 East Northern Parkway, Jessica Bingham.
Yes,
Afternoon, Ms. Bingham. We have this as an application to install a rooftop telecommunications facility consisting of 8 antennas with rooftop equipment at this location. Is that correct?
that's correct.
All right. Mr. French, anything from the planning department with regard to this application?
Yes, Planning Department recommends approval of this application subject to these conditions. Where visible from the street, antennas and related equipment must be painted to ensure they are visually unobtrusive. Panel antennas and related equipment will remain mounted as illustrated in the plans and elevations submitted to planning, and the applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
All right. Ms. Bingham, are you amenable to those conditions offered by the planning department?
Yes,
Okay. And is there anything further you would like to add to supplement your application in this appeal?
no,
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve the appeal.
thank you.
Good luck. All right. Next, we're going to take those cases where opposition is signed in, and frequently we found that opposition is a result of either a lack of communication or miscommunication among the parties, and frequently it can be useful to offer the parties an opportunity to have it in dialogue amongst themselves to see if they can resolve whatever issues they have between them. Obviously, if there are two sides involved in a dispute, and those sides come forward and ask the board to resolve their dispute, one of those two sides is bound to go away disappointed with the outcome. So this is your opportunity to avoid that unhappy fate. I'm going to call the cases off where opposition has signed in and offer you an opportunity to, well, I'll ask if there has been any dialogue between the parties and also ask whether or not the parties desire to either continue or to enter into a dialogue now to see if they can resolve their differences. If you can't, then that's fine, and if you don't want to speak one another, you certainly don't have to, but we certainly do encourage and appreciate it. When I call off the cases where opposition is signed in, the sides can just stand where they are. You don't need to come forward at this time, but just stand where you are and I'll pose the questions to you as we call those cases. 2017-367, 3009 St. Paul Street, Lee Giroux. I saw Ms. Giroux here just a moment ago.
It's probably in the lobby.
Okay, have a seat. We'll skip that and we'll call the next one. 2017-380, 1100 Falls Hill Drive, Mr. Berry. And who else is here on that case? Okay. And have you folks had an opportunity to have a discussion? Okay. Any hope of further dialogue resolving the differences, Mr. Berry?
Right not.
Okay, all right. Have a seat. We'll call you in turn. 2017-410, 1821 through 1831 West Lafayette Avenue, Tammy Rollins. Okay, and have you folks had an opportunity to speak? All right, where's Ms. Rollins? Who's the applicant here? Are they present? Okay. Okay, we'll have a seat and we'll see if they show up. All right. Other one, opposition is signed in 2017-413, 2000 East Baltimore Street. This is you, Mr. Berry? We've got this as Mr. Prettle. I'm not sure if you're here covering for that as well.
He'll be here in a minute. We can continue talking.
Okay.
It's the last item on the agenda.
Yes, it is. Any dialogue between the parties or desire to continue dialogue?
I'm here from the neighborhood, but I was unaware to have 3 more protesters here from the neighborhood.
Okay.
So they have.
All right, and Ms. Witt, are you here on that case as well? No? Okay. If you folks would like to talk, you are at the end of the docket, so certainly wouldn't hurt you. But again, it's not mandatory. We won't put you on the rack if you don't, but again, we certainly do encourage it. All right, you can have a seat. In 2017, that's 367, 3009 St. Paul Street, Ms. Giroux, and who else is on that? All right, Ms. Witt, are you here on that case? Yes. Okay, and has there been dialogue between the parties in this case?
There has been between, I believe, the community and the owner of the property, not between the two of us.
Okay, and any desire to continue to have a dialogue?
Yes, we do.
Yes, okay, all right. We'll call you in turn. Have a seat. Which case are you here on?
That case.
They're speaking right there if you would like to.
The community has not had dialogue with the owner.
Okay, right there, you can, I think that you would be welcome to participate. All right, calling the first case, 2017-403, 3138 Chestnut Avenue, William Bauer. All right, Mr. Bauer, we have this as an application to use the first floor as an art gallery and gift shop and the second floor as a dwelling unit. Is that correct?
Yes, it is.
All right. If all those intending to give testimony in this case can raise their right hand and be sworn, please.
Swear or affirm under the penalties of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information related.
Yes.
All right. Do we have staff reports?
Yes, the Planning Department has reviewed this application. noted that this property is eligible for designation as a neighborhood commercial establishment based on the existing structure on the property and the zoning of the property. The department notes that the use must be confined to the building itself, and the signs are restricted to those allowed in a C1 zoning district. Subject to those conditions, the Department of Planning recommends approval of the application, subject to the condition that the business complies with all provisions and requirements of the zoning code relating to neighborhood commercial establishments. Thank you.
Thank you. All right, and Mr. Bauer, are those conditions offered by the planning department acceptable to you?
Yes, absolutely.
All right, why don't you tell us about what's being sought here?
I'll introduce you to Mr. Kyle, the property owner, and Ms. Mina, his partner.
Hello.
Afternoon.
So looking to open up an art gallery and a small gift shop to sell art-related items.
Okay. And what do we know about the structure located at this location?
We found that since 1931, it was a grocery store. And then Mr. Kyle bought the building about,
15 years ago now.
Okay. And what's it been, I guess, when was it built?
not sure when it was built.
1920-ish.
Okay. And I guess the earliest use that we have evidence of is as a grocery store?
Grocery, yes, 1931.
As well as coal and wood and those kinds of things for getting through the day.
Understand. Different definition of the grocery store back in 1931. All right, and do we have any photographs of the property? We've got the aerials, but
I think we did submit a few of the pictures of the facade when we originally filed. Yeah, there we go. It still has some of the original painting for the brick where they identified the shop.
Arnold's.
all right, so the art gallery use will just be on the first floor then?
Correct.
All right. And we got the floor plan somewhere in here. All right, so I guess the gallery will be in the front, and the gift shop that you spoke of will be located behind that, and then there'll be an office space.
Correct.
Okay. Any other questions? All right. Thank you all very much.
Thank you very much. Have a great day.
Take care.
Sir, I didn't catch your name. But-
Okay. Calling the next case, 2017-402, 3724 through 3726 Eastern Avenue, Gurpreet Singh.
Good afternoon, Mr. Chairman. For the record, Frank Boozer on behalf of Mr. Singh.
Afternoon. What was the last name, counsel?
Boozer, B-O-O-Z-E-R.
Okay. All right, and Mr. Boozer, we have this as an application to add live entertainment and dancing to an existing first-floor tavern and liquor store, correct?
That's correct.
All right. If all those intending to give testimony in this matter can raise their right hands and be sworn.
Swear or affirm under the penalties of perjury that the testimony you're about to give is true and correct to the best of your knowledge and information.
Yes, sir.
All right, do we have staff reports?
Yes, we have a letter from the Highlandtown Community Association dated November 7th. The right to express that the association's opposition to the proposed zoning appeal regarding the business at 3724-26 Eastern Avenue. Due to previous complaints from neighbors, we oppose the addition of live entertainment at this business, commonly known as Main Street Bar and Liquors. Specifically, the association disputes the applicant's claim that the only residences are located more than block and a half away. The association would like to note that the residences at the 400 block of South Eden Street are directly behind the alley behind 3724 Eastern Avenue. These residences have been regularly and routinely affected by the activities at this location. And then we have planning's report.
Thank you. Planning Department reviewed this application, noted that it included a floor plan which, although there is a reference to dancing in the application, does not include a designated area as a dance floor. Also, the application does not include any plans with regard to parking, sanitation, or traffic management, as it states that the proposed use would not bring in additional patrons. The department notes that these are requirements that the application should address. For these reasons, and for the fact that the department noted that the applicant proposes to have live entertainment and dancing during the hours that the place is open, 11 a.m. to 2 a.m., the Department of Planning recommends a deferral of a complete hearing of the application to allow the applicant to revise the floor plan to show where dancing would occur and to confirm whether live entertainment would actually be provided during all operating hours of the existing establishment. Thank you.
Thank you. Mr. French, given that it was brought up by the Community Association, does the Planning Department take any position regarding the suitability of live entertainment at this location, given the adjacent residential properties?
The block of Eastern Avenue where this property is located is designated as commercial. This is basically the main street for the Highlandtown area. The property is designated within the Highlandtown business area or renewal plan area as commercial. Residential effects would be presumably based upon the residences on the other side of the alley behind the property. The department therefore doesn't see necessarily a problem with impact on nearby residential property, provided that there is direction of the sound away from that residential property.
Thank you. All right, and Mr. Boozer, the Planning Department is seeking deferral of this case pending the issues which they raised in their report. You willing to defer this hearing to address those?
If I may ask a question, I just want to make sure which copy of the plan that you all have. I have a plan that was submitted. I guess I could submit this as petitioner's one that shows the dancing area on here. It's an indication of planning. That's an insignificant designation as to what it shows or what it purports to be. We, of course, can change that, but I want to make sure that they, in fact, have that same plan that shows that there is a dancing area, noting that was a major concern.
You want to provide that to Mr. French?
Sure.
Yes, the plan that was made available to the department is the base plan without the markup that shows a DJ room and a dancing area, which is on this plan that's being presented today.
Okay. Is what's being sufficient, is what's being submitted sufficient or not sufficient for a planning department?
Well, that appears to show a dance floor area. It does show where a DJ would be located as far as, playing the recorded music that they're proposing to have. So the department would not necessarily have any further objection if this plan is considered adequate by the board.
Okay, and then as far as the parking issues which the department raised?
Well, the department is concerned, obviously, that the purpose of live entertainment normally is to increase the patronage of an establishment, not merely to maintain it at its existing level, and that there appeared to be no provisions being made for any possible increase in patronage of this property.
Commissioner, I can speak to that directly. The reason for this application is really an abundance of caution. My client had been cited for people dancing in his establishment. Of course, there is music. It is a bar. And people were dancing. When inspectors would come in, they would cite people. And he literally had something out of the 1920s, signs posted around his establishment saying no dancing. We'd have to ask patrons to sit down. This application is to merely allow patrons who are already there to dance. The indication that, which is correct, that the majority of the requests for live entertainment are to bring in live entertainment acts to advertise, to bring in further patrons. That is not my client's intent. He, in fact, is the one that DJs, if you can call it that, 90% of the time he plays the music on his iPod at the bar. People dance, or sometimes another patron will ask if they can play the music, and they plug in their electronic device. So when you say live entertainment, it is to basically allow what is going on right now. He won't be bringing in any live acts. He won't bring in any paid entertainers in any kind of way. And therefore, I think it would have de minimis impact, if any, on any parking or any other health, safety, or welfare concern. Is that correct, Mr. Singh? And you've owned the establishment for 6 years now. You actually bought it when you were 21 years old, and you're 27 now. And did I accurately convey to the board what goes on a daily basis at your establishment?
Yes.
And is it your intention to,
Counsel, if you could have
I
Mr.
apologize.
Singh use the microphone too.
is it your intention to do, as I indicated, to try to allow people to dance as they normally already are? You're not going to bring in any outside acts or paid entertainers or any other what we would commonly refer to, not by the zoning regulations, but in common parlance, as live entertainment acts of any kind. You'll just be playing the music as you normally do. And if your patrons want to dance, you're asking them to be allowed to dance.
That's correct.
And do you see in any way that this is going to bring more people to your bar?
No, because it continues as is. It's just, I just want my customers to be able to dance and not get violated. That's all.
So with that testimony, and of course I'd ask, I'm not sure if the board wants 7 more copies of this? I'm not sure if
No,
a
I believe that we have it.
Okay, I'm not sure if a deferral is necessary at this time, unless the board has any other questions in light of the clarification on those 2 issues.
Where do the patrons currently park?
You can,
On the street? Sorry.
and the majority of your patrons from around the neighborhood?
Not really. They come from everywhere. But if they're driving, they park on Eastern Avenue. And I would like to also add that, the 3700 block, it's not, every business is not open till 2 o'clock like mine. So there's basically hardly any traffic, just a laundromat that's right next to my building. Their customers park on the street, but for the rest of the time, the street is available for them to park. So.
Okay, and you're seeking permission for live entertainment from 11 a.m. until 12 a.m.
11 to 2, I believe, is that correct?
11 to 2. Yes.
And how many nights a week would that be?
7 nights, 7 days, because I never know. You never know when somebody will come in and sit down. It's a Spanish bar. We play bachata, merengue, salsa. So, somebody comes in and they start dancing, and then inspector comes in at 11 in the morning, which has happened, and says, hey, why are these people dancing? What am I gonna say? So that's why I asked from open to close, because I'm not, like Mr. Boozer said, I'm not bringing any special acts. I'm not gonna do, special shows where the DJ shows off, or nothing like that. It's just so people can dance and we can play music there, that's all.
Okay. Any desire to cut the music off and limit it until, say,
Oh, I always,
8 until 2?
yeah, that's fine, I always, start turning off the music at 1:30, and then from 1:30 to 2 o'clock, I clear out the house.
You haven't had any problems with the neighbors on the
No.
adjacent street, have you, at any
No.
time?
No.
And you're planning to
I
do
mean-
things just the same now as you have been doing, is that correct?
Yeah, that's correct.
Again, it falls into that age-old what is live entertainment category, which of course by the zoning rules is quite broad. But I think it's a bit draconian that his patrons are not allowed to dance, and he's being cited for that, even when it's not a live act.
Well, you can take that up with your council person. All right. Any other questions? All right. Thank you very much.
Thank you.
Ms. Witt. Is Ms. Giroux? There we go. Okay. Are you guys done talking? All right. 2017-367, 3009 St. Paul Street, Lee Giroux.
People are going to be testifying, they should come up. So, Pat LaPage.
Councilwoman, good to see you again. Ms. Giroux, likewise.
Good afternoon.
And you too, Ms. Witt.
Thank you.
Ms. Giroux, we have this as an application to use as 4 dwelling units with 2 off-street parking spaces in the rear yard. Is that correct?
That's correct, but the correction is it's 1 parking space.
Okay. 1 parking space. All right. All right, if all those intending to give testimony can raise their right hands and be sworn, please.
Do you swear or affirm under the penalties of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief?
I do.
All right, do we have staff reports?
Yes. First, we have a letter from the Charles Village Civic Association dated November 4th. The association strongly opposes the application to use 4 dwelling units in a residential property, 3009 St. Paul Street, that has consistently been used as a single-family home since at least 1968. Past property owners and nearby residents will testify that 3009 St. Paul Street has been used as a single-family residence since 1968. Records show zoning for office use in early 1960s, but our community has no recollection of the office at that time. The current owner converted the single-family property into 4 very small apartment units with only 2 parking spaces without obtaining building permits. The impact of this conversion worsens parking congestion and negatively impacts the quality of life for surrounding neighbors in a premier residential block in Charles Village. The association requests that this conversion be denied. We have a letter from a resident. Okay, they write, my husband and I are very disheartened when we learned that our neighbor, who owns 3009, converted the property into a multiple family space without going through proper channels. This is a nice, safe neighborhood in which we could raise our child family. We felt the neighborhood had great family feel and were hoping our other families would move in so that our daughter will have kids to play with. We are deeply concerned with the lack of consideration that people who rent seem to have regarding their home environment, and they will not be able to maintain the property in a similar fashion to us as primary homeowners. It is our understanding that the owner indicated that the home was so expensive that no one could afford to live in it unless it was converted into a multiple unit building, but that is not true. We purchased our home and have invested resources to make it livable and will continue to fix the place up once we move in. It is our understanding that more and more single-family homes are being converted over to multiple family homes, and we must not allow this to continue. We need to keep aspects of the neighborhood family-friendly. We have a letter from Councilwoman Mary Pat Clark in summary in both the 1971 and in 2017 zoning codes. Any conversion of a single-family house in the R8 district requires approval by ordinance from the City Council. As an immediate prior owner, Mr. Sturgeon has written that he and his family sold 3009 to the current owner in November 2015 as a single-family house in which the Sturgeons lived for 14 years, leaving the design and feature of the house virtually intact from 2001, their move-in, until 2015. She asks, how could such a major conversion happen without the city's intervention regarding legal and legislative requirements? The answer is the owner failed to seek or secure any Baltimore City construction permits whatsoever for such a construction project. I'm almost done. If successful, this appeal would represent a setback of confidence in the block in Charles Village and in the city itself. And then there's planning's report.
Thank you. Planning Department reviewed this application and also reviewed records available to it concerning the use of the property. The property was last officially permitted to be used as offices in 1962, and there was no record available to the Planning Department of its reversion to any other use or conversion to any other use, residential or otherwise, since that time. On that basis, the department considers the office use a non-conforming use under the current zoning, and therefore that the applicant is proposing essentially to extinguish a non-conforming use, which would be the office use and substitute residential use. The department notes that there is only one parking space that would meet zoning code standards that could be provided in the rear of the property, and therefore a parking variance of 75% would be required. The department notes that this proposed use would extinguish non-conforming use of the property and thus has no objection to the application. Thank you.
Thank you. And Mr. French, I guess, first, Councilwoman.
Yes, sir.
I guess you can come up and use the microphone.
Good afternoon.
Good afternoon. Am I recalling the letters correctly, that it was your letter that recounted the
Law.
what? The position, that is the report from the prior owner as to.
Oh, yes, yes, and I have a copy of that. I presume that you do too, Sandy, but I brought a copy. I know, but I mean, I have a copy to give. I know.
One at a
Here
time.
is here is the whole letter that he sent to, this is Sandy Sparks, and I just quoted from it. Yes, sir.
Okay.
And
So-
yeah.
All right. And Mr. French, if we take the position, if we take the information reported by the prior owner as true, that they lived at the house from 2001 through 2015, and that the use of the property was as a residential dwelling, what would the position of the planning department be at that point regarding the request to use the property as a four-apartment, or a four-unit dwelling, a 4DU structure?
If the board was to find that the property has in fact been a single-family dwelling prior to this, and the applicant is requesting conversion to multiple-family dwelling use, then under the zoning code, that must be accomplished by ordinance, and the board would therefore have no jurisdiction to approve this appeal, if that was the situation.
If I could
Okay.
hop in just for a very brief moment. We not only have that email from Mr. Sturgeon, we actually have the former owner before Mr. Sturgeon of the property from 1968, or she lived there from 1968 to 2001, who, she's right here, who would testify that she used it as a single-family residence only.
Okay, and really, I don't want to jump into the opposition right now. I
Yeah.
just wanted to get some input from the planning department regarding their position on what, sort of what's been, the information that's been provided from the prior owner, so that the board can be aware of that. And then we'll proceed as we typically do by starting with the applicant. So we'll get to your folks in a moment.
May I just add that the Baltimore City Council in all these, in this case, has never been asked to introduce an ordinance, has never introduced one, has never enacted one that changed the status of this house from single family. Thank you.
Thank you, Councilman. All right, Ms. Drew.
Good afternoon.
Afternoon.
Okay. To start with, the way that the interpretation of this building under the previous owners, the last owner prior to my customer owning the building never applied for use and occupancy. So it was used, if in fact it was used illegally for a single-family dwelling. There's never been a vacant building notice attached to this building throughout this process. Johns Hopkins University used it as a last legal use, and it was back on 10/25 of '63 when they actually applied for the use and occupancy, and they were approved. And since then, there has never been a single-family dwelling use and occupancy ever applied for. So I just wanted to reiterate that, and I wanted to introduce this information. This is the information from the city.
Do we have any photographs of the interior?
I can provide you with about 100 of them, except that I happen to be here.
But I
Oh,
mean,
her.
from the.
Oh, no, I don't have them with me. I'm so sorry. No, I don't. The plans are current.
You said that the plans are current.
They are
Does that mean
current.
that it reflects?
What's there
the-
now? Yes. Mhm.
All right, and so that we have the account from the prior owner.
I also have the settlement sheet, which doesn't indicate that it's a single-family house.
All right, and have you seen this letter, Ms. Drew?
From,
The email from the prior owner?
no, I have not.
Okay,
We just had a discussion outside.
okay,
Yeah.
I'll just read it all into the record.
Okay.
All right. This is from a John Sturgeon. I'm looking at the settlement sheet which you provided. And the name and address of the seller listed on the settlement statement is John F. Sturgeon, 3009 St. Paul Street, Baltimore, Maryland, 21218. So it would appear that this is a letter from the prior owner. Addressed to Ms. Witt. It's dated Halloween, Tuesday, October 31st, 2017 at 3:14 p.m. Regarding 3009 St. Paul Avenue. It may well be St. Paul Street, but the title of the email is Ray 3009 St. Paul Avenue. Just as a sort of housekeeping point, we're going to follow the rules that we all learned as children, which is speak when spoken to or when asked to speak. Because the reason for that is we have a court reporter here and he's taking down everything. And so if there are stray comments made by people whom he does not know, it makes his job very difficult. So we have to make sure that before anyone speaks, that they've identified themselves for the record, we've got their names correctly spelled, et cetera, and that's going to make our record much easier. Okay, so Ray 3009 St. Paul Avenue, hyphen single family home when sold in 2015, question mark. I take that is, yes, I believe that was the title of the email sent by Ms. Witt, to which Mr. Sturgeon is responding. He begins, Becky Witt. In short, yes, as stated in all sales information, it was a 5-bedroom, single-family home. The sale was finalized in the fall of 2015, 11/19/15. My wife and I bought the house in 2001. Since we were both working artists and academics with no children, we used 3 of the bedrooms as office/studio spaces and kept one as a guest bedroom, along with our bedroom. Rather amazingly, we were just the 3rd owner of the dwelling, even though the house was built in 1901. To my knowledge, the house was largely as it was originally designed when we purchased it, and remained so until we sold it in 2015, with all the classic hardwood floors, high curved ceilings, faux fireplaces, etc. We made no architectural modifications during our ownership. The final sale coincided with my relocation to Las Vegas, Nevada in 2015. I would refer you to my realtor, Allison Dickinson at Hill & Company. It provides her email address, AllisonDickinson@hillrealtors.com, for corroboration and details on the sale, its condition, as well as her photos of the house as a single-family dwelling. Frankly, I can attest that Mr. Adireja, J.A., was an extremely difficult person to deal with and produced an unnecessarily protracted sales process. Even though we were under contract, he brought many of the due dates for paperwork or action to the very limit, in some cases well beyond the limit. I was so frustrated at several points, I seriously considered pulling the plug in order to seek another buyer. Even after the sale was finalized, I had bills from Baltimore City coming to me. Being the responsible party as the new owner, he failed to file a proper transfer of ownership papers in a timely manner. It was a mess that took months to rectify. So I find your contention that he went forward with renovations without the necessary permits totally in keeping with his established MO, as my realtor and I knew from the sales process. Good luck in your pursuit. Best, John. Signed, John Sturgeon, 9179 Penn Station Street, Las Vegas, Nevada, 89123. Okay, so that's the email that that he provided. And from the settlement sheet that you've handed up, it doesn't look like there's really anything on here as to the use of the property. Just kind of going through here quickly. No, doesn't look like there's anything on there regarding the use of the property. We do have a SDAT, real property data sheet showing that indeed Mr. Sturgeon did sell the property, although the date of the settlement sheet is November 19, 2015. The date of the transfer per SDAT was in May of 2016. But under use, it says residential and principal residence no. So there's that. And you said that you do not have any photographs of the interior or anything like that?
No, I had my draftsman who works with me, basically go in and measure every part of the building as is right now, and these are his drawings as it
Okay.
exists. My understanding is that there were 4 bedrooms in the home before this, but the offices were the things that John Hopkins obviously had legally been approved for, and like I said, there was no vacant house or vacant building notice. There's never been a certificate of occupancy applied for a single family throughout this whole process. So there's not a conversion. And even though this is R8 and all, the new zoning code has now taken effect, and we've applied for this appeal at this point, basically those rules, there were some rules before June 1st that would have applied here, but not now. And under Title IX, Section 9-701, this is the subtitle. This is where it shows that if it was considered a single family, then it would be allowed as multifamily. And the last thing is that in this neighborhood, in Charles Village, as we all know, there are a lot of Hopkins students, and the market that we are focusing on and the people that would be living in any of these apartments would be people who are professional people. That was a focus just because of where the location is. And essentially, that's how he feels about it. I agree with him, and at this point, we're not doing a conversion.
Okay, and what about the statement from Mr. Sturgeon that the property, when he owned it, was a single-family home? They didn't do any alterations, changes, et cetera. Looking at your drawings, there appear to be walls separating. Did you want this part of the record, by the way?
Yes, please.
Okay. There appear to be walls separating the various areas. So it's separating out the respective living spaces. On the first floor shows a one-bedroom apartment with a kitchen and a bathroom, or a kitchen/dining area and a bathroom, as well as a common area. But the common area is separated from the apartment, which takes up roughly half of the floor area shown. On the second floor, there's an efficiency unit in the front portion of the property with, again, a kitchen and bath area, a wall separating that area out from the stairs, and then across that hallway area at the top of the stairs appears to be another wall with a kitchen/dining area, bathroom, and one-bedroom apartment next to there. And then on the fourth floor, it seems that the entire floor is a apartment with a kitchen area, a bath area, and 2 bedrooms with a living room/dining area there. So that wouldn't. It sounds like it's not consistent with the design of a single-family house that Mr. Sturgeon recounted. So was there any work done by your client on the interior of the property since he purchased it?
Yes, I asked him in detail about that because I was concerned. And, you know, I do things in compliance myself. And basically I said, well, you know, you need to go to the permit officer or call or whatever. And he said he had come down and he said he put doors up and he had done some work. And he was told by the permit office directly, and this is a statement yesterday to me over the phone, that he was told he didn't have to have any permits for interior. I don't know who could have told him that, but that was his answer. And I said, well, that's just not acceptable. And we do have new people across the street. I understand there's people in the office that have given me 2 different versions of the same thing. It doesn't excuse that. And so I had a very long discussion with him, and he assumed, as the investors did as well, that because there are other properties on that street as well as in the community that have 2, 3, or 4 apartments in them, and consistently Calvert Street, St. Paul Street, all through Charles Village because of Hopkins University and their needs, that he was able to do this. And that when he bought the property, it was his understanding that he had no issues. And he didn't even think he would have to come here, which is another reason. He's had the property since 2015. He would have applied for it before then, he said. So I have to take that. And at 3015, we have 4 dwelling units. Okay, and so there's something that's there. And then 3017, there's 2 dwelling units. So we do have multi-dwelling units within the neighborhood and within the same block. And I'm not being, you know, not sympathetic to the neighbors in this case. And certainly they are trying to keep their neighborhood as such. But it's not about the financial. It's all about what's allowed. And what's allowed is this is not a conversion. This is from offices, which was the last legal use, to a 4 dwelling unit with 1 parking space.
Okay.
Okay.
Thank you.
You're welcome.
Ms. Witt.
So, Becky Witt, on behalf of the Charles Village Civic Association, in opposition to this matter, whether we're calling it a conversion or whatever else we're calling it. The main argument is that the CVCA would like to point out, and I think we've kind of gone over this already, is that the planning department and others base their evaluation on this non-conforming use that they assumed had been ongoing because they didn't receive any information to the contrary. But that use has been extinguished based on the information that you already read into the record from Mr. Sturgeon and based on community testimony that we're going to present. So I guess, should we go in order going this way of people who would like to speak? So first is Sandy Sparks from the CVCA. And could you just introduce yourself and state your role with CVCA and then tell the board what you'd like to tell them?
Yes, Sandy Sparks. I am immediate past president of the Charles Village Civic Association, and I continue on the board and serve as the chair of the Charles Village Civic Association's Land Use Committee, which meets on the first Tuesday of each month. This issue came to our attention because there was a posting done, and typically we receive notice of this in advance and have it presented as an application to create these dwelling units. This was not the case. This, in fact, was already converted to apartments, the single family, in the single family dwelling. So this is really illegal, which is why the Civic Association hired the Community Law Center to represent us, because we believe this is absolutely illegal. And we were very fortunate to have the near neighbors who've been there many, many years. And in fact, one of the occupant prior, the owner occupant prior to Mr. Sturgeon here, who happens to be here from Vermont, who'd lived there for 33 years. So there's decades of history of this being a single-family house. And so the Civic Association absolutely does not want to see the illegal conversion of properties to multifamily without going through the proper process.
All right, thank you.
Thank you.
Okay. You want to step up, Patricia? This is Patricia LePage. And can you talk a little bit about your relationship to the property?
Yes. I'm Patricia LePage. My husband and I moved into the property in January of 1968 with our 3 children. We rented the property. It was Frederick Realty who presided over the rental. I didn't ever meet the owner because I was told she was an elderly lady living in Catonsville in a nursing home who had received the property from her husband's parents as a life estate. And they were divorced very shortly afterwards, so she moved out of the property, and it was rented after that time. I never heard of anything about having to apply for some sort of special document saying that it had been used for anything else. The property was unchanged inside when we moved in. The fireplaces were all there, the ceilings, everything that Mr. Sturgeon put into his letter. There were 3 rooms on the first floor, 1 kitchen. There were 3 rooms on the second floor, 3 bedrooms, 1 bathroom. There were 3 rooms on the third floor. 2 of the rooms are very small, and there was 1 bathroom there. There was no parking at that time. We had a garden, a garden in the backyard. When we moved into the neighborhood, the reason that I'm so disheartened in seeing what has happened is that it was a wonderful neighborhood, and people were coming into that neighborhood trying to kind of reclaim the city, I guess, as a viable place to live. My husband played with the Baltimore Symphony, and that's why we moved there. They often had either a rehearsal in the morning or a concert at night, or 2 rehearsals, and it was very difficult. We had been living in Annapolis to go back and forth. And so when we found this house, we were delighted. We brought our children up there. The youngest one was 6 months old when we moved in. He was 33 when we moved out. And the houses, 6 in a row, as other people have testified, were all private residences. My children all had kids to play with. And it wasn't that big. That's the thing. When I think of 4 families living in that house, it wasn't that big. And we had 1 car. I didn't even drive at the time, and I can remember my husband being like half-hour late coming back from a concert because he'd been driving around trying to find a place to park. So the idea of 4 families worth of cars just seems, really excessive. In any case, I still can't believe that somebody could have converted this building to apartment use without any permits, any permission, any zoning permission, anything. In any case, it was sold and bought twice, and through realtors. And by the way, the previous owner had apparently lost the property during the Depression, and there was some loan due. USF&G was actually the holder of that loan. That's where our settlement took place. And nobody brought up the subject that the house had been termed office space and needed to be reconverted. There was just no discussion about that at all. And if I remember correctly, they had a lawyer present. So I didn't even, I never heard anything about that. But I can absolutely swear to you that it's been a private dwelling for a very long time.
Okay, there's a zoning summary card on file from one of which is from 1962, which I guess you said you purchased the property in 1968.
No, we moved in 68 and rented it till 76 when the elderly lady with the life estate died.
Okay, so you moved in 68. All right. So this is in 62. This is used the building for educational research offices, 10 persons employed, operated by Johns Hopkins University. Like you said that you purchased the property from an elderly woman who you never met.
Yeah.
All right.
And we rented it from Frederick Realty, and they never told us who the previous tenant was. Normally, when buildings are rented, they don't tell you who the previous tenant was. But we realized it was Hopkins because when my kids were playing downstairs in the basement one time, they found a big pile of papers with a lot of Hopkins material in there. So we surmised that it was Hopkins. That's the only way we even knew.
Okay. And when you purchased the property, when you moved into the property, rather, it was set up and used as a single-family residence.
Yep. There was nothing, not a single partition, just living room, dining room, kitchen, and upstairs bedrooms, and the fireplaces and the floors, and there was just no evidence. We had no idea it had ever been used as office space until midway sometime in our tenancy. And as I say, one of the children brought this pile of papers up, and it says something about Hopkins Ballistics Lab or something.
Okay. And then there's similarly, I guess on the second card, it's dated October 24th, 1963. Basically says the same thing. Use entire building for education, research offices, 10 persons employed, operated by Johns Hopkins University. I guess maybe the fact that the second card follows, I guess, a year and a month after the first, maybe that coincides with the expiration of a lease. But other than that, there's no other information given. Okay, Ms. Witt.
Thank you. All right. I think Mary Pat Clark would like to, you said you wanted to be next?
No.
You just want to be heard at some point?
Yeah, I just want to be on the list.
Okay.
Your list.
Okay. Why don't you state your name and your address and what you want to tell the board about how this would
Sure.
impact your community?
So my name is Jennifer Eliseyev, ELISSEEFF, and I live at 3007 St. Paul Street. I bought the house over 16 years ago. It was my first home purchase, starting my job with a 2-year-old daughter. I work at Johns Hopkins, and I was building my home. And I thought this was possible because I was the 4th owner in 100 years, just like John Sturgeon mentioned in his property. I saw the neighbors next door that had raised their children there, and it was a row of 6 single-family homes. So it seemed like a great place to really live where I work. I work at Johns Hopkins, and I really care about the community. I raised my daughter there. She attended City College High School. I have a local scholarship to a local kid I'm sending to school. I was appointed by Governor Hogan for the board of directors of TEDCO. I care about economic development. I care about community here. So I get very passionate about this, so I apologize if I'm a little bit on edge, but I care a lot about it. And I have both practical and personal concerns with this. From the practical perspective, I can tell you there was months of renovations that happened. Months and months of work was done on the property. So there was significant change happening. I am concerned about even the safety of the electrical and all of that stuff that was done, meeting some of the workers. I am concerned about that in addition to the lack of permits. I can tell you there's still one trash can for 4 apartments, so there's trash all over the place. This morning there were 2 parking spots, 2 cars in the parking spots. Last night there were 2 cars in the parking spot. Multiple times since this house has been sold, I have had guests or people who live in that house parking in my parking spots. So I come home from a long day of work and I'm tired, and there's a car from this place in my parking pad, right? And, you know, I've had to deal with multiple upgrades in my house. I've invested a lot in my house. I'm considering another investment and improvement in this house, and I'm not sure if I should do that if this is what's happening next door to me. So there is a high turnover of renters in the apartment. As a professor at Hopkins, I love students, and I live in my community, and I care about students, and I support students. So that's not an issue. But this is about doing what's right. This is the community. I care about the community. And Baltimore is a place that, you know, treats homeowners and communities like this. It's not right. And I know many people at Hopkins. I'm happy to go search and try to understand more about what the building was used for at Johns Hopkins. But, you know, personally, this is my home. And it makes a big impact, right? And I'm all for economic development, but this is not the way to make it happen. So I'm happy to answer any questions that you might have, and hopefully I didn't miss anything.
That's good.
Thank you.
All right. You state your name.
My name is Sandra Waters. I live at 3013 St. Paul Street. I moved into Charles Village in 1965 in the 2900 block of St. Paul. Saw a sign, house for sale, by owner in the 3000 block of St. Paul. And my husband and I bought it in 1969. I have lived in 3013 St. Paul Street for 48 years. It is a single-family house. I have known Pat LePage since we moved in. I can say that there was never an office in that house, that I knew the family. I spent many days, many nights in the house visiting, in the backyard, dinner. I know the house very well. My daughter played with her children. One of the reasons that Charles Village is so unique is that we have a very big diversity of people. We like having students, but we want them in the proper perspective. There are single-family owners who should be respected. We like having young people, old people, dogs, babies. It's a unique residential area. And if people are permitted to illegally turn houses into apartments, that should be punished. This particular owner owns other properties. He owns 2818 North Calvert Street. I have counted mailboxes. There are 7 mailboxes. I understand that they have permission to have 4 rental units there. He told me with great pride he owned property in Roland Park. I have seen this man at auctions bidding on houses to buy. This is a beautiful residential area, and I can vouch for the LePage family as being a family without an office. Thank you, sir. Thank you.
All right, next person.
My name is Peter Duvall. That's D-U-V-A-L-L. I work for Strong City, Baltimore, and I also live in Charles Village, and I'm on the Land Use Committee. First of all, I talked to or emailed the owners of 3011 St. Paul Street, the people that already have a letter on file. They are rehabbing their house as a historic rehab. They've been working on it for over a year, and they've pulled 7 permits so far, probably more to go. They've done everything right, jumped through all the hoops. If that had been the case here, we would have been talking a year and a half ago, resolving this before the work had been done. The owner, as the owner of other apartments, knows that there's registration and licensing requirements for multifamily buildings. He owns other ones. Yet for some reason, he hasn't voluntarily complied with any of those rules. This is not his only apartment building in Charles Village. To me, he appears to be doing his best to not do what he knows is required. I don't want to make accusations, but that's the way it appears to me from the outside. Next door neighbors, investing, doing historic rehab, getting 7 permits. Hopefully they'll move in soon, but they're doing a lot of work, just like the neighbor on the other side. Thank you.
Thank you.
Who's next? Do you guys want to be on the record? Yeah? Okay. Can you introduce yourself?
Sure. My name is Evelyn Tyson, and I've lived in Charles Village for 18 years. I live on 27th Street, and currently I have a neighbor who has been illegally converting a single-family home into apartments slowly. The city's aware of it. I just came from inspections and zoning right before I came here, and I saw the sign about the hearing yesterday, and I'm very involved with the community and the association. And my issue is that if you allow this to continue without making him convert it, it sets a precedent to let people who do not live here. Everyone I know who owns an apartment building in Charles Village doesn't live here. They're happy to take money out of Baltimore, but they don't want to live here. And I'm watching this beautiful community turn into apartment village. And we have enough apartments. We have enough housing for students. We don't have enough parking. We don't have enough single-family houses. And while I appreciate you as an attorney digging into the year of JFK's assassination to pull out this office use, I don't feel that, I admire it as an attorney, but I don't feel that pulling this out as an excuse for an owner who knows you're supposed to get building permits. And he knew what he was buying. I found over and over that people, I think what obsessed me the most is that these houses are gorgeous and they're like beautiful women. And when you chop them up, it's like drawing and quartering Heidi Klum, something. So, yeah, Sandy's telling me not to be so dramatic. But that's how I feel about it. They're beautiful, and then they're desecrated. And it should be turned back into what it was, Thank you.
Thanks.
Hi, I'm Elizabeth Armstrong. That's Elisabeth. I live at 3020 St. Paul, and I have lived there just over 2 years. And the point that I want to make is that people are moving in and are buying single-family homes to live there as single-family homes. So this isn't what the economy has to have. Thank you.
I'm Arthur Dan Gleckler. I live at 2726
You might need to spell your name.
Gleckler. I live at 2726 St. Paul Street. My wife and I bought that house in 1967, so lived there 50 years. Rather soon after we moved in, I got a real estate license, and even though I had other jobs, I focused on Charles Village, and for about 20 years, I was a significant actor in the stabilizing of the neighborhood. And these folks I knew and have worked with them on boards and so on. Soon after we moved in, and soon after I got my real estate license and dealt only in Charles Village real estate, a new zoning ordinance, I think it was 1971, came in. And at that time, it was very clear that you couldn't convert a single family into multiples without hearings. And so that's certainly been the case here. My experience over the years has been that single family houses have stabilized and strengthened the whole community. If you have 6 or 8 on a block that has 40 houses, even though a lot of them are converted, the single-family houses act as a strong stabilizer and promoter for the neighborhood. And so to lose a single-family house has always been a significant detraction. I don't know, I can't remember any where that has happened in these years since that zoning ordinance, as far as Charles Village is concerned. And certainly the legality of it shocks me too. So I would just say that it's been very important to maintain single-family houses. They have sold always very well. We've never had a problem saying that you couldn't get a sale if the house was single-family. And just one more thing, as far as I understand, if Hopkins used it as offices, they didn't need to make any conversions. They could just put a desk in a bedroom or a living room or whatever. So we don't have any evidence that there was any kind of conversion. Plus we have the people who have said that they lived in the house and it was a single-family house. So anyway, I support the insistence that it be returned to single-family use.
One question, sir.
Yes.
Since you said that you were involved in real estate in the area, do you have any prior experience in your professional life as a realtor with this property at all?
Not with this, and I knew Leo, he was in the symphony, and of course knew Sandy.
Okay.
But, that was as just his friends, neighbors.
All right, so you don't recall the...
3009 specifically.
All right, so you don't recall it being listed for rent at all at that period of time, or? Okay, thank you very much.
Okay, I think we have two more.
I think that we might have gotten the gist of it.
Yeah, I think it's, I mean, the councilwoman,
Of course.
she says what she's gonna say.
Right. I'll be brief. You have my letters coming down, but it's been mostly read and discussed, actually. Let me just say this. This is my legislation, so I know it well, and it was approved in the time of the 1971 zoning code. And it said that in R7 and R8 neighborhoods, zoning districts, conversion to multifamily or to more than one unit of a single-family house required a Baltimore City Council ordinance. Now, this house has never applied for that ordinance or legislation. I think it's been established that it's a single-family house. It certainly has been for decades. If there was an office there and everybody went and applied for that use, and it was part of the record before the zoning code of 1971, it was a non-conforming use that has long ago disappeared into the vapor because it was for maybe a year, maybe two, but it was back in the 60s before. We only have hand records. We don't have them online. So basically, what I'm saying is, as a member of the city council and as a representative of this area, this is a single-family house as far as the law is concerned because it hasn't been converted by city council ordinance. So I just want to say that we are here with the idea of parking spaces and lot size with regard to a multifamily house. And I would just like to take us back to say, there is no multifamily house. It hasn't happened. And it's important that we not just ignore the lack of permits, the lack of legislative authority, and just say, well, that's how it goes, because it sets a very bad precedent, not just in Charles Village, but throughout the community. The law is the law, and this gentleman obviously knew what it was because he's got plenty of properties. He just decided to do what he wanted to do without permits, legislation, or anything else. And I'm here to say, hey, there's a reason for the law. Thank you.
Thank you.
Just to wrap up in 1 minute, Councilwoman Clark is going to put me out of business because she really said all the things that I wanted to say. I just wanted to highlight that we're really here under the variance analysis, from what I understand. And any hardship that's been created here that a variance would solve is, as the neighbors have said over and over again, completely self-inflicted, and not really for any other purpose besides the desire to increase the value of the property. So I would argue that the owner does not qualify for a variance under that analysis, and he does not qualify to use this property as a multifamily home.
Thank you. Ms. Rue.
Okay, I have a couple of points to make. First being that previous owner, before my customer bought the property, would know better, especially under the assumption that when you buy a property, it needs to be inspected, and the use and occupancy certificate is issued against inspections. And in the case where Hopkins had the certificate of occupancy, the argument here is basically they were inspected and they were issued against the paperwork. So I respectfully disagree with the gentleman saying that, you know,
What about
Hopkins had a
the
certificate of
argument
occupancy.
raised by, sorry for the interruption, but what about the argument raised by the councilwoman that regardless of what the use may have been in 1963 and 64, that the zoning code wasn't enacted until 1971.
Correct.
And so it would be the use that was made of the property as of that time, and that given the testimony from the witness who was residing at the property from 1968 until, I guess, 2001, that the property was used as of 1971 as a single-family residential property, that it is that use which that this board has to recognize as the use of the property.
Right, but also the rules apply even prior to this, that last tenant and owner was subject to the zoning codes, was subject to inspections and all the things that go with the use and occupancy, and never applied for that.
Well,
The whole process. So there's never been, on record, a single-family dwelling legally in this, from the time that Hopkins gave up the space and sold it. And you look at the SDAT, I've looked at that as well. There's been no registration of this property, and they would know better, and they would be advised. And even currently and recently, when someone owns something, even in 2000, they would know. And I'm sorry that this is a very strong group, and I'm sure that they have meetings and they certainly do discuss things, but this property has never been registered until now, and it's a property registration is in the system for this, pending the inspections. So I have a problem with the fact that we have a previous owner who's claiming they rented and then bought it, but never went through the process either. And there's never been a vacant building notice or a house notice. So there's been continuous use, but there's never been anything that states single family. I brought the proof today, even with regards to the settlement paper. I asked my customer, I said, where is it referenced on your settlement? And I read it and I didn't see it, and I gave it to you as, you know, submitting. There is no reference to this ever being single family dwelling and being sold as, and it actually, I think you stated that it was none on the settlement
Well,
paper.
typically on HUD 1, you would not find that information. I mean, it's not significant that it's not there. That's
Okay.
just not normally included.
Okay, but what I'm buying is, am I buying multi-use? What am I buying? You know, there has to be some definition
Well,
somewhere.
To that point, even if your client, when he purchased the property, if the of-record use at that time was as an office, and let's say that he's charged with constructive notice of that, and he goes to the property, he looks around it, he sees it, clearly it's been used as a residence, according to Mr. Sturgeon's testimony, well, according to his letter. And so he sees on the one hand that, all right, well, the property is supposed to be an office, But yet, I'm looking around and I see that this isn't an office, this is somebody's house. Would he have an obligation at that point to investigate the matter further, or would he be entitled to still continue on with the belief that he was buying an office property?
Well, he went under the assumption that he was told that this was bought as a four-dwelling potential property here because it was already offices from Hopkins. He didn't have any other proof for me, didn't come to me, other than he said next door, basically on the same block, 3015, which I've confirmed today, even with this group, is 4 dwelling units. So he went with the assumption that, yes, if there was 4 offices there, why couldn't I put in 4 apartments? He's thinking more in commercial, not the residential components, because he thought he bought a property that represented 4 offices. And that's what the last legal use of this building was. There's been no changes since. There's been no conversions. There's been illegal conversions for people to live there and put bedrooms in that have never gotten permits to do that as well. That's obvious. So now you're looking at a building he bought basically and is sold as office space. He accepted it as is for the price, but he looked at it in a different way.
Okay.
Renters are potential buyers. I disagree with the arguments. The people that are there in this neighborhood, yes, we want to stabilize neighborhoods everywhere. And who's to say that a person that moves there is not potentially going to rent with the option to buy? And under the economic conditions, as we all know, that there are some people that have down payments available to them, but then there's some that do not. But there are those rental agreements where there's an option to buy. So that is not what I'm looking at as a viable argument. And again, the previous owners didn't have a use in occupancy. We're asking for 1 parking space. We're asking for a 25% variance in the analysis. And we've come up with that the offices were established through an inspection through the city. And the certificate of occupancy back then, the C of O, which is indicated right on the sheet I gave you, it was established because the city came in and said to Hopkins, yes, you can have these 4 offices, and it met all the criteria back there and back then, but it has not been converted.
Let me just back you up. You
Sure.
talked about the parking variance. Planning said that it was 75% variance required here, and you had just mentioned
I thought it was 25. I apologize.
I think that's the lot area variance.
Yes, I'm so sorry.
Yeah, so it'd be 1 per dwelling unit, and
Right.
there's only 1 provided.
Yes.
Right.
The previous owner's email referenced the realtor by email address. Was there any contact with that realtor to gather any of the marketing materials or description of the property?
The one thing that I do have that I've had forgotten to submit at the end was this printout from Coldwell Banker with the listing, or what's left of the listing, because it's not an active listing anymore, for this property when it was sold in 2015, which I would like to submit. And it does say, sorry, it printed a little bit strangely, but at the top of page 2, this is the listing. Wow, one of the original grand dames of Charles Village, charming home in a vibrant block with loads of original features. It's listed as a single-family, 5-bedroom house.
And I have to argue that point, that basically that's a realtor making a broad statement without going to the zoning, without looking at the records, and making a statement. And 90% of my customers over the past 20 years run into buildings like this where they buy something, they're not aware of what the zoning is or not, and we have a problem.
If I were a potential buyer and I was reading this,
I understand.
how would I get the impression that I was buying previously something that was several offices?
Well, I would, right. My point is that the realtors don't necessarily go to the zoning cards to look before they list something like this and put a description in. And I have a problem with that. Title companies, as we know, have to do their due diligence, and they have to do their homework, and they make mistakes. But they're covered by the errors and omissions.
The description is something that
Right.
is a description of
But that's someone's opinion.
what it was at
So-
the time the description.
That's someone's opinion, but it wasn't without the realtor not being able to go and make a phone call to the zoning office to verify whether or not there was a previous use. As we know, there's a lot of buildings that were that were represented throughout the city, even the corner buildings, for instance, where they say, oh, they're a multifamily or a multi-dwelling or they're multi-use. Well, then it becomes a very generic argument. You know, is it this or has it been that? I have another building that Hopkins had that they never registered, and a client from last year that he bought a building thinking he bought something that it was misrepresented by the real estate office and the title company.
But
I don't know if they have
one of the
exemptions.
witnesses brought it up that this isn't your client's first foray into real estate investment and purchases of real estate.
Right, he's successfully doing 2 properties that I've been helping him with down in Fells Point, and he's done it in compliance. We've just passed all of the codes, we've passed everything else.
But he has a number of other investment properties as well that he's purchased over the years.
He's a relatively new customer. The other 2 are the first ones I've worked with him on, and this is the third. So
But I mean,
this is,
prior
but
to
obviously
his
there's
encounter with you,
other
bought and
properties.
sold.
Obviously, he has owned that I'm not aware of.
Okay, all right. Okay, any other questions?
Thank you. Thank you very much.
2017-380, 1100 Falls Hill Drive.
The first time I've heard anybody reference the 71 code as the new code.
Yes. Okay, Mr. Berry, since we have you up here, I've got a note that as to 2017-413, that is 2000 East Baltimore Street, that the applicant and the opposition agree to postpone that case for 2 weeks for further discussion. Is that correct?
That's correct. Your suggestion that we talk some more, and some more people showed up from the neighborhood that weren't at the other meetings, so we're going to postpone it for 2 weeks, if that's okay.
Okay, so 2017-413, 2000 East Baltimore Street is postponed.
Put up the existing condition.
Get on in 2 weeks? If we know they can get on in 2 weeks.
Existing condition, put the existing conditions. That was on one of them.
And as to,
Oh, okay. Oh, yeah, let's put it.
and as to this matter, Mr. Berry, that is 2017-380, 1100 Falls Hill Drive. We have that described as an application to subdivide lot and construct 16 single-family row house dwellings with shared private driveway to front parking pads as access to front garages and a stormwater management lot. Is that correct?
That's correct.
All right. Will all those intending to give testimony in this matter raise their right hands to be sworn, please?
Do you swear or affirm under the penalties of perjury that the testimony you're about to give is true and correct to the best of your knowledge and information?
Right. Do we have staff reports?
Yes, we have a letter from, signed by 3 presidents of 3 community associations, Heathbrook Community Organization, Hose Heights Improvement Association, and the Medfield Community Association. They write that they have met with the developer on November 5th, 2017. After numerous discussions with the developer, we determined the requested variances are solely for the developer's financial gain and convenience. We therefore feel that the number of units should be reduced with different width buildings, and therein the variances would not be required. Granting these variances would lead to undue concentrations of population, increasing congestion, and overbuilding are going on everywhere, adversely affecting our community and the life in our neighborhood. We also have the letter from Mary Pat Clark to summarize my thanks to the board and to the applicant for permitting the postponement, but that they regret after meeting that this neighborhood will be losing its last green space and habitat of any size, where all 3 boundaries of the 3 neighborhoods meet. As for the variances, the Hose Height neighborhood has opposed any variance changes, arguing that a new zoning code has just been adopted, which sets standards for the city. It is the developer who is asking for relief to these regulations. She thanks you, and then there's a similar letter from Hose Heights. It was written back in October previously to the postponement, and then there's planning's report.
Thank you. Planning Department has reviewed this application. The department has also had conversations with the developer in terms of laying out a subdivision plan that would be approvable for presentation to the Planning Commission. There are, as stated in the letters just referenced, some variances that may be required based upon the final version of the plan. The department also notes that this is a hillside property, and therefore there are certain issues involved with the topography. The department does not object to the application as a general concept, subject to the condition that the proposed subdivision and development plan is approved by the Planning Commission. Thank you.
Thank you. All right, and Mr. Barry, are those conditions stated by the Planning Department acceptable to you?
Yes, they are.
All right. Why don't you tell us about what's being sought here and the proposal that's being made?
Let me pass out to the board previous correspondence that we were going to give at the last meeting before it was postponed. And I want to just begin by saying we were disappointed at the recent letter from the community associations. When we agreed to the postponement at the request of Councilwoman Clark and the communities, it was explicitly to basically amend a previous community benefits agreement that the developer and owner had entered into for a 32-unit apartment building that was approved under a subdivision plan by the Planning Commission and a development plan by the Planning Commission, and we'll go into that. That happened last year, November of last year. Approximately 50 feet in height, 32-unit apartment building was approved. At that time, the neighborhoods did enter into an agreement about access, construction, fencing, and so one of the reasons that we agreed to a postponement was under the premise that was stated out in the lobby that we were going to amend that to change it from the apartment building to the single-family townhouses. In discussions with the community, they then said, oh no, we want you to take off 2 more houses because we think it will lower the number of variances needed. And I'll get into that. So we're disappointed. We've negotiated, I think, in good faith beginning in April of this year, and we'll talk about the reasons why we believe the board can approve and should approve this revised plan. Before I get too much into the details of the arguments, though, I would like our civil engineer, and we'll all introduce ourselves, to explain this site, because it is a unique site for several reasons. And I think it's important, and it distinguishes it from both some of the surrounding properties, much less the general zoning properties in the neighborhood. Kevin, do you want to introduce yourself?
Okay, my name's Kevin Garvey, and I'm with D.S. Thaler & Associates, and I'm acting as the lead planner on this project. This site is rather unique in that it's at the outside corner of an intersection. Normal city blocks, you know, kind of more in a grid system. So this severely limits the access to the site. And that compounded with the topography just made it a real challenge to design, you know, a townhome community there. Which is consistent with the neighborhood. They've got townhomes to the north there, also on the south side of Falls Road. The other driver of the design, we really looked at a lot of different options for the design coming straight in, but we need to provide turnaround for the fire access. And the fire department requires a 60-foot from the center line over, and that really just requires us to put the townhomes up along the edge there. The angle, oh, Yeah, I mean, then a lot of the setbacks are really due to the angle of the lot lines. And so although we're asking for variances, but it's only for a little corner of the piece of property. It's not like a whole unit.
Okay, thank you, Kevin. What I'd like then to explain that the other site conditions, which you can see from this plan, specifically the fact that the side yard variances that are being requested here and here, or not that one.
Just the rear yard.
The rear yard variance is there, but no, there's a, if you look at what's surrounding the property, you have vacant lots, these two vacant lots, which the owner was going to buy. but The neighborhood asked them not to. This is an apartment building complex just to the south. This is an apartment complex just to the west. And surrounding it, you've got a vacant city-owned property, which is here. So the distance, the effective distance between this property and any adjoining houses, I think it's over 100 feet, if I'm not mistaken. So the impact of any reduction in the one house or two houses that have a reduced rear yard is minimal, if any, on the neighborhood. The suggestion by the neighborhood to take two houses and substitute perhaps wider houses, these are 16-foot wide houses, substitute wider houses wouldn't reduce the number of variances for the fewer houses. It would actually have a similar footprint to this plan. The houses would just get wider and they would take up the same amount of space and maybe have the same setback variances requested. I just want to show the board the comparison between this plan and the approved apartment plan that was approved by the Planning Commission, just for comparison. The developer, recognizing the successful sales at something called Skyview, which is about a block away, has been selling very well. And so he felt that it was legitimate to go to the neighborhood and substitute the home ownership, single-family townhouses, for the apartment building, 32-unit apartment building. Apartments are profitable, 32 units. We have an agreement with the neighborhood toward that. They may not have been entirely happy with it. I'm not going to say that. But we did have an agreement to build the 32-unit apartment building. In good faith, we went back and said, would you rather have 16 townhouses that'll be homeowners rather than the 32 apartments? And you can look at the relative impact. My professional opinion is that the impact of the townhouses that are going to be under 40 feet, as opposed to the 50-foot height, a part of that apartment building, is actually better for the neighborhood. But we need a variance. And the height variance we're looking at, frankly, is only because if we were to have a sloped roof, a mansard-type roof on the fourth floor, the 35-foot height limit is allowed to go to the middle of the pitch. But we want a flat roof. We think it's a better appearance. It's an overall lower height, and so we're asking for that as well. We've met with the planning department, the fire department, site plan review committee. We would need your variance approvals before we could then submit for subdivision plan, which would get into final design approvals and subdivision approval by the Planning Commission. I would like to just point out that we believe that it meets the standards that the zoning code. For uniqueness, you've already heard testimony from the Civil Engineering Office that the site is unique. You won't find, I think, any other site within this neighborhood that meets these same conditions. We don't have alleys from the rear of the property that we could provide access from. We don't have a long frontage of properties. So we're constrained from that standpoint, and none of that's the fault of the developer. Practical difficulty. I've said this before on a number of occasions. When you develop infill sites in the city and you balance the need for stormwater management, forest conservation, the lot line requirements, which are really designed, even under Transform Baltimore, for a more regular grid city pattern, some things will change. The variances we need for lot coverage, I think, go between, I think it's on here, are minimal. Basically, the lot size reductions are between 8 square feet out of, I think, 1,500 square foot requirements. So we're almost meet those regardless. The 4 to 10 feet reductions for side yards for not all the properties. And the one rear yard building, which is, as Kevin said, which is at the corner, which is close to where you can see the property angles off. And we were going to buy the property next to it, but the neighborhood said not to. Part of the agreement with the associations was to put a fence up, and I'll have the developer explain those negotiations, because they wanted to be walled off from this. They wanted to be walled off. They didn't want access through from the neighborhoods, through the property, to get to Falls Road. We've agreed to do that. And now they're asking, in a sense, either no development because they want to protect the green space, or they want 2 less units. The difference between 16 and 18 units in terms of traffic congestion or development of the property, I think is hard to imagine would be that much of an impact. The last thing I would say or argue is that public interest, again, we would make the argument that the home ownership and then all the meetings we've had with the neighborhood, and I think even their correspondence, it says they prefer home ownership to apartments. So we think that's clearly in the public interest. And for comprehensive plan consistency, there is no plan that we have found in the city's comprehensive plan that designates this property for open space. There are properties in the city that are proposed for open space. There's an open space. The property behind it that I pointed out, the triangle, was actually designated by Councilwoman Clark as public open space. But this property was not designated as open space or for open space conservation. It's half the density of what's allowed under Transform Baltimore. So we're not overcrowding the property, and we think it's consistent with the city's goal to attract more homeowners here. So with that, I would argue, we'll listen to the neighborhood comments as well, that it meets the standards that the board is required to find, and hopefully you will approve it today.
Thank you.
This is our lead person.
Okay.
Hi, I'm Craig Huntley. I am a civil engineer. Not in development engineering, but I've done this, so this is my first rodeo. I've known Al for 23, 24 years. Luke is my next door neighbor, so it's not personal. And the letter that you received from the 3 communities, I think, outlined a little bit about the variances. Also, the letter that came from Hose Heights 2 weeks ago stated the intent to go from the request to go from 16 to 14. So it has been on the table since at least that letter came out. That isn't
representing a specific community association?
I think I'm the planning and zoning person for Heathbrook. Our president was unable to make it today, but we met on Sunday, all 3 presidents and additional neighborhood people to discuss it. So I guess I'm speaking officially for the community. Couple things. When we talk about this site being unique, it's a little frustrating to me because the grid system is the unique site for infill in Baltimore. There's not calling something a different shape. That's what infill is in Baltimore. So to say it's an infill shape and it's got issues with the slope and the access, that's what development is about. You have to deal with the site, but it's not unique. We have sites with this kind of grading at Falls Hill, just around the corner. Same kind of elevation issues. In the last year, we've had, pardon? Skyview. So what did I say? Skyview. In the last year, we had Rotunda come online in our neighborhood. We've had Skyview, Carnes Lane, Redfern, Crittenden, and Knoxell are all projects that are in the works for additional property being developed, as well as the falls at Roland Park, our Falls Hill, Headwind, and the Coca-Cola plant coming up soon.
Well, looking at the zoning map that we have here, this does seem to be the largest unimproved lot in this zoning area.
It is.
Isn't it? Okay. Doesn't that fact by itself make it unique?
unique in a good way. I don't think it's unique in that you're saying it makes it harder to work with. You've got more land to work with. And to talk about the change in the variances, I have done the numbers on it. If you change, right now there are 9 properties that are being requested for lot size, minimum lot size. 9 of the 16 are asking for variances for lot size. 7 of them are for lot size, 9 of them are for coverage. If you change to a 17-foot lot, you would get rid of all of the minimum lot. If you change to an 8-foot size but kept the same footprint, square footage, you would eliminate the variances for the percent lot coverage as well as the lot size. So you could take care of that, and by shifting them over, then you would eliminate at least 1, and I believe 2, of the 3 side variances or front and rear variances. And one of the variances I'm not sure about. It says 25-foot and 25-foot is required, so I'm not quite sure about that one. But by increasing the size of the building and the size of the lot, but increasing the width of the building, keeping the size of the building, you would eliminate all those variances. That's why we came up with 14 instead of 16, not just as a minimizing people, but we've got variances for a reason. This could be done with 14, not 16, and the only reason, the benefit of this is to make it easier on the developer and increase the number of houses and the value of the property. We didn't ask for it to be walled off. We were looking to cut down on additional parking issues, that if you provide parking, people will walk around and try to find parking and walking through it. That was the purpose of the fencing. The height variance, we didn't say that we were opposed to that because we understand where that one's coming from. It is a lot, when you're doing the taller ceilinged rooms in houses that are the new development, you're gonna need a taller building. The houses around it have 8-foot ceilings and are lower, and they're all 2-story for the houses nearby. So that's my main points, that we have we do recognize that 16 lots is less than the 32, but we think that you're still asking variances only for the convenience of the developer and the profit of the developer. And by any houses in this area, we are so overdeveloped in this area and so much more coming online. Parking in the time we've been there, we've lived there for 17 years. Parking has gotten much harder. Traffic is worse. The intersection that this is coming out on is also going to be the only intersection for Skyview. So we've got 2 properties coming out on the Falls Road in an area that is already difficult. Anything else I forgot?
Well, you're in charge, so if you did, you can step back and
I'll
knock
step
me
back
over.
and not let you go.
Okay. These are copies of my letter to the board. There should be enough there for the board and a staff person. Mary Pat Clark, Baltimore City Council. Very proud to represent this area and these 3 neighborhoods. Actually, this site, Falls Hill, is where these 3 neighborhoods come together. It's sort of their meeting point. Down the west side of the hill is Medfield. This specific location is in the Heathbrook neighborhood, but it's right up against the Hose Heights neighborhood where Skyview is. Did I give you the wrong thing? It's possible.
Just a stray
You've given us
staff
too
report.
much.
It's always the problem. I'm sorry. So basically, the west side is Medfield, down the hill, and the 1,100 blocks there to Falls Road. And Heathbrook is where the lot is actually located, but abutting Hose Heights, where Skyview is actually located, which is so similar to this lot. It's like 2 hilltops divided by a common driveway. So I would like to say that this is actually the last, if that makes it unique, it is the last real open space that the neighbors have. Skyview's gone. And that wedge, I mean, is city-owned. This is privately owned here, the one that we're talking about. So I would just like to say that you've heard from Lydia Wilson, who is the president of Hose Heights, and she, in all sincerity to me, said when these negotiations and discussions were going on, you just adopted a new zoning code. Why can't you stick with those rules? She's been through so much with Skyview, and it's been such a struggle. And we've lost all that green space. But actually, the greenness of the space is matched by a couple of lots of green across in Heathbrook, but not of that size whatsoever. This is the green space leaving. And people are kind of discouraged by that because these are nature lovers here in these communities. But so let me just go to the second page of what I've written and talk about variance findings. And I'll just read it so I get it right. Pertaining to the requested variances in general, the board is asked to first find that the purpose of the variance is not based exclusively on a desire to increase the value or income potential of the property. Actually, we think it might be. The developer indicated to the community that he changed his plans to townhouses when he, and there's nothing wrong with this, except it does make the point. He realized the marketability and high sales prices of the townhouses being built next door on the Skyview hilltop. And neighbors certainly do prefer townhouses to an apartment complex. But even though some variances relate to additional on-site parking, which favor the existing neighborhoods, a reduction of even 2 townhouses, as President Wilson recommends, might help reduce the overall excessive coverage of impervious surfaces and help ensure that the development and its remaining variances, quote unquote, will not overcrowd the land. Going back up, if I may, or unduly compromise the environment. Going back up to the top of this page, that reduction by 2 townhouses, I'm in first paragraph, would enable a reconfiguration to address those 13 of the lots in this collection, which exceed by 20% to 22% the maximum permitted impervious surface in an R6 district. And about the disappointment, I don't recall this the specific comment that was made, but let me say that we asked for a chance for the community to have more time to work on this with the developer on this community benefits agreement. I can attest, because I've got calls and I know that the community met for hours to try to come up with a proposal to the developer that he could accept. And then they met with him. I was not there. They met with him, and then they later told me that they couldn't support this appeal because they couldn't come to an agreement on the agreement. So whatever else, we had asked for time for the communities to work on this, and indeed, I know they did, from the emails back and forth and the like. So these are wonderful people. They live in the midst of a construction site by reason of, I guess, being in the 21211 zip. It's a hardship, and a lot of green is getting lost in the process. But I think there's a solution, and I think it has to do with removing 2 of those houses and keeping them the same size, but just giving us all more breathing room and not so overcrowding the lot. Thank you.
Thank you.
Michael Servette, 1129 Rowland Heights Ave. I'm just going to state a couple of facts. I actually was a structural engineer for 12 years. I worked with architects, MEPs, builders. I'm just to understand that there is a zoning requirement, and as far as I can tell, there is, the reason for these variances is just to increase the value of the property. I don't see any other reason for it. We're not asking for this person not to build. We're just asking to follow the rules. And it's not so unique that you cannot build a development there if these variances aren't granted. Of course, something can be built. And it doesn't necessarily have to be 2 less houses. Maybe there's a million variations that will follow, the plan without asking for variances. 2 is just what we came up with. But so again, no one is asking for him not to build. That's the way of the future. It's going to be that way. But just why do you have zoning ordinances? If any time someone just wants to make more money and asks for a pass, then we shouldn't have any zoning variances, because why are they there? Why are the rules there? So we're just saying follow the rules. We'd love to keep the woods. We know we're probably not going to be able to, but just follow the rules. And if the only reason you don't want to follow the rules is to make more money, I understand that. I think we all would want to do that, but that's just not the way it goes as far as I am led to believe. So that's all I want to say. I'm not going to get emotional, just facts. So.
Good afternoon. My name is Edith Stanford. I live at 1017 Roland Heights Avenue. We've been there, as Craig said, we've been there for 17 years. We have 1 poly grad and 1 coming up, so sorry for any of you city people. Sorry about that football game. This is a biodiversity report that we had created last year. As Mary Pat stated, the green space is very important to us. And as Michael reiterated, we understand that it's unlikely that we will have complete preservation, but we think that it's important that the information be taken into consideration. I also want to point out that with the letter from the different community associations, we hope that you can recognize that that represents a number of people. As you all know, because you work for a living during the day, there were lots of folks who weren't able to be here today. Ours is a community of working folks, and they're at their jobs, and they're sorry they can't be here, but they hope that the letter will represent their perspective. Roland Heights Avenue is currently under study for traffic, for speed and excessive traffic. So obviously, the more units, the more traffic that we're going to experience. We have a lot of cut-through traffic. That's our primarily traffic issue. And then in addition to the green space, I think the only other thing is I find it kind of upsetting that I understand that the developer has talked to neighbors and told them that if they do not support the townhouse option, they could end up with Section 8 housing. And I find that very distasteful in a city that needs more affordable housing. Thank you.
Thank you. Thank you.
I was going to have the developer give a response.
I didn't know if
They have more to say.
Yeah.
It's just going to close for us. Right?
Okay, you can, yes, this is your last time.
Okay. I think between everybody who's spoken, we kind of hit all the points that we wanted to make. That we feel like the neighborhood is really being overdeveloped, and 2 houses does make a difference when you're looking over this many developments in the area. It does. I've looked at it. I think that we've said that the parking, additional parking in front, we understand those. The height, we're not questioning that, but we think that the setbacks, maximum lot coverage, and the minimum lot size are things that could be easily resolved by reducing the number of units. I've looked at it. I know that that would make the difference. I think that's it.
Can I ask a quick question? I've heard some testimony in terms of the quote-unquote success of the Skyview development. Do you know how many units were built and how many are sold at this point?
There are 3 sticks.
I don't really care who answers it. It's just.
It's Luke Yorkart. There's 40 units. I think at the moment 36 of them have been sold.
36?
And they're asking for the permits to get the next group built, and that.
So there's another phase.
Well, no, 40 is the limit.
No, it's sales and was separate from construction.
Thank you.
Okay, is that it? Yep. All right, Mr. Berry.
Okay, I want to have owner and developer say a few words, but I just want to say that, remind the board that, yes, Transform Baltimore was passed, as we all know. Yes, there are regulations. If you look at the specific variances that are needed, many of which we would still need, even if the houses were reduced by 2, so the findings would have to be the same. You'd have to make the same findings that the site is unique, that we're not doing this solely for the increased economic feasibility of the project or the developer, and that this is a unique site. I think you heard testimony from our civil engineer that this site is unusual, both in this neighborhood and for any number of reasons. And we started out with actually one more house when we started the planning for this at the corner, but we moved it, we eliminated that house before we even showed it to the neighborhood to try to increase the setback even on that corner. So maybe Mr. Hart can just speak briefly to address some of the neighborhood process that he's had throughout this project.
Okay.
Hi, my name is Luke Yorkhart. That's LUKEYORKE-HART. I'm a resident in the neighborhood. I live a block away. I live next to Craig over here. I am also a civil engineer. I have actively practiced in development engineering in both the city and in Baltimore County. I'm also a fledgling home builder in the city, Baltimore-based, building homes in the city. We are the most affordable home builder in the neighborhood. We have got an active subdivision where we're building 15 townhomes in Medfield. That's just the introduction. And I just want to confirm that the board has these. Yes, sir.
You're building that under the, doing business as D.S. Taylor?
No, D.S. Taylor is the engineering firm we hire. I'm just an engineer by profession as well. I run the home building company and deal with all land planning and land development aspects thereof. So I just want to confirm that the board has the zoning plan dated the 23rd of October 2017.
That matches our letter with the public variances matches.
Mm-hmm. Yeah, that's what I was going to go.
September 20th, 17? That's a date of mine.
The plan that was part of the letter I gave,
Yes, that one's got the news plan.
Oh, okay.
that's October 23rd.
Yeah, and I can maybe deal with it point by point, especially since I've been involved in it for about 2 years now. Firstly, just on a few points that were raised by the community. Just firstly, actually started the process by having a meeting with Mary Pat Clark to discuss purchase of the city-owned parcel. I was also in active negotiations with Ms. Priest, who owns that parcel, to purchase that from her, and we had approached the owner of that land. Since we were asked by the community to stop, we stopped purchasing any adjacent property to respect that request. Just on the uniqueness of the site, the zoning code, in my experience, having dealt with this before as well, is generally written for a very typical symmetrical square block with typical access and a grid system in the city. I'll get back to the numbers later. Just wanted to highlight also the fence was specifically asked for all around the property to completely cut off any foot traffic. So not only is there a green buffer all around it, the bulk of the community that's here is actually, per request, separated from that development through not purchasing the land, through putting up a fence, and through the buffer. Skyview is similar. I think they have way more non-conforming lots, but it was a PUD. And then the last thing I want to highlight is the difference between profitability and viability. So profitability and maximizing is completely different from having a basic viable site that does comply with the density requirements in the zoning code. I won't speak on the uniqueness and practical difficulty. I think that says for itself. Everyone else has spoken on that. The main issue is let's speak about the profitability. We started with a 32-unit multifamily building, massed considerably larger. I think the footprint's about 16,000 square feet. We're proposing a total square feet of 11,500. Not only that, I think at the peak height to the top of the roof is over 60 feet on the highest point on the building. We're only at 40 feet. It's a significantly small operation. The main reason for doing that is it's become more viable since Skyview operated, and secondly, we transformed ourselves from just a normal development company into a home building company. We're based in Baltimore. We build houses in Baltimore.
I'm sorry, that's what I was getting. What's the name of that?
Emerald Builders. We build both for ourselves and for clients as well. So those are the points I would like to write to address in terms of profitability. Then just to address perhaps some of the specific variances, because I think a lot of things were put around. In the first plan that we presented to the city, there were 17 townhomes. The only variances that we requested were to do with parking in the front and to do with the non-conforming width of the right-of-way. Each lot was conforming. Each house that we've specifically designed, it's a standard house. It's a 16 by 45 foot house. It has to be that deep so the stairs can reach up in a single rise. We were then asked to firstly move them back to accommodate the wider right-of-way, which is reiterated when we met with the fire department that asked us to move the buildings even further back. So what happened is these buildings moved back a lot and these a little bit. All the ratios, if I look at variance requests 1, 3, and 4 are function of the lot depth. If I think I worked it out, I also ran my calculations. If the fire department and the city give us back 4 feet, then we're done. Then all those variances disappear, except for the rear yard variance over there for 21 feet. I've spoken to the property owner most affected there, and she said it doesn't bother her. It's very far. I walked out with her. She ended up purchasing this lot instead of me. So obviously it was for sale. And she's comfortable with that. All the other variances are internal. There's a massive buffer to the community on the outside per their request on numerous different layers. And just to reiterate running the numbers, if I were to change these to 18-foot standard plans, which would be the next size, the net change here would be 0 because you have 19 times 2 is 18 feet. The square foot of the building would be exactly the same. The delta here would be 4 feet decrease in size, which is negligible. So this it won't give us anything there. We just lose 2 units. The question I posed to the community in our final negotiations was, how does it impact you? From my side, I feel that since the beginning, the community's asked me, especially the ones on the outside, please, we want to be separated from this development. Don't purchase the land, which I was going to put in a conservation easement. Please put up the fence. Everything's orientated inwards, the access, everything. It's a pocket neighborhood. We've used some very sophisticated planning and design, good effort from the estate's office. So we're not asking for any major variances. I think if I go through them, each one of the lot area is between 8 feet and 48 square feet and 60 square feet. I think it's like 2, 3, 4 percentage points. The max lot coverage is the maximum coverage is 50%, but they vary from 45 to 50%. It's all within 5 percentage points. Then a setback, lot 9. I think there is a side, I don't know where the side is still applied, but there are some interior setbacks and then that rear setback. So the change in massing, we looked at various layouts. Unfortunately, the site is governed because of the topography. We can't put this driveway anywhere else. That's the only place we have access. It's the only way we can get the grade that the fire department requires. There's no other layout for the site. And that on top of the fact that it doesn't matter how we mass it, we're going to end up at the same thing. Even if we go to the 18-foot units, lose 2 units, the coverage will be the same. We might meet the minimum lot requirements in terms of size. The coverage would still be non-conforming. That ratio would stay constant. So there would be a very small impact.
What's your density?
16 units, allowed is 32 units. So we halve the allowed density, and we're halving the density from the approved multi-family building. So again, in terms of profitability, it's not like I'm pushing the envelope here.
What do you estimate building out per square foot?
They're just under 2,000 square feet.
Yeah, but what is your direct cost per square foot?
My all indirect, just direct construction costs, it's about $75 a square foot, excluding land and site
You
development.
add your indirect,
That's indirect, that's everything excluding land development.
right?
Yeah.
So you should be all in around 100 per square foot?
I'm not sure what the it's 75 per square foot indirect, anything to do with vertical construction. If I add the cost to acquire the land, subdivide it and develop it, I can tell you we operate at a 12% net margin on that, if that makes any difference. It's not going to make it more or less profitable. It goes about the viability for me, not about the profitability. The viability drops at a lower density. Also, we're trying to develop energy efficient small units.
Heard if the other project down the street's selling for 400,000.
Correct, exactly. So previously we had a lower sales price, which made it unviable. Now the sales price has increased, making the project viable for townhomes. And obviously on a personal level, I do live there. I would prefer townhomes. And then just finishing up on the community, I have been working with them for 6.5 months just on this iteration. I've sent them numerous plans. 2 weeks ago when I met outside was the first time any comment was made in terms of changing the layout. I've been working and asking and needed the input, and that's the first time I really got that. Previously everything was just opposed. I don't know what else to say. That covers it.
Unless there are any questions from the board?
All right.
Thank you very much.
Thank you.
All right. Thank you all very much. No.
Or I'm done? Okay. Thank you. Thank you, Chairman.
No. Okay, all right. Take a 5-minute break.
Oh, second shift's here.
Yeah, she snuck in.
Uh-oh. I'm having arthritic issues.
Stop running.
What was that, guys?
Oh!
Yeah, that's what I was thinking.
All this time. Mohammed Chauhan or Mohammed Khan? Mohammed Chauhan or Mohammed Khan? Are either of them here?
They're not here, but we're here.
Understood.
Our orthopedist is ready to send me to the glue factory.
Really?
I've been told you need to stop running. You can't run anymore. I know you want to keep running. There's no way to make you keep running and still be healthy. Tough pill to swallow. No, it's actually my hips. I'm so out of whack that that affects everything else. Ease the sobering realization.
You do a bicycle?
Oh, yeah, I do. Apparently not.
Running is tough when you're fine.
That's what we're gonna have next. I know.
Okay, works for me.
That's what I do.
I'm still 30.
Okay. Go back on the record. All right. All right. I'm going to call 2017-410, 1821 through 1831 West Lafayette Avenue. Tammy Rollins.
It's opposition.
Well, come forward. No, come on. Calling again, 2017-410, 1821 through 1831 West Lafayette Avenue, Tammy Rollins. All right. Mr. Baumgartner, did we have any response or interaction with the applicant in this case?
We do not, and the file reflects that this appeal was made on October 4th. There's a posting notice in the file. We have not returned the signed posting notice back. That's all the information we have.
Okay. Did anyone here see the posted sign? Okay. If all those intending to give testimony in this matter can raise their right hand and be sworn, please.
Swear or affirm under the penalties of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief. Yes.
Okay. Who wants to be sort of the designated person? You'd like, I guess. Okay. All right. If you both would step up to the microphones, please. Can you identify yourselves for the record?
I'm Angel Devilbus, and I live at 808 North Monroe Street.
Okay, and ma'am, if you would spell your last name.
D as in David, E as in ever. D as in David, E as in ever, V as in Victor, I, L as in love, B as in boy, I, S, that's 2 S's, as in Sarah.
Okay. And ma'am, your name and address for the record.
Inez Robb, I-N-E-Z. The last name is R as in Robert, O as in other, B as in boy, B as in boy.
Okay. And Ms. Devilbus and Rob, I'd asked about the posted sign for this hearing. Did either of you observe a posted sign for this hearing?
No.
There was no posted sign.
Okay. And how did you find out about this hearing?
Well, I go to the store every day, and of course, my
You go to
friends.
what store every day?
The gas station, and they told me that there was a court date, and I was like, really? Nobody called me, and I didn't see any sign.
She's referring to the BP across
Yeah,
the street.
they're going to BP at 900 North Monroe.
Okay.
1900.
All right. And
I thought it was
Ms. Rob?
900.
Oh, it may be 900.
Yeah, it's 9.
I received a phone call from you guys stating there was a new date, and then I also received something in the mail because I was here for the last hearing.
That was going to be my next question. Was you were here for the prior hearing regarding this property?
Yes.
All right. So
As
you,
was I.
okay, and you, at least you, Ms. Robb, received notice from the zoning board office about the date and time of this hearing?
Yes.
Okay. The applicant, having not appeared, will mark as a no-show, and the matter is dismissed.
Thank you.
Thank you all.
So you
Should I
need
give you
nothing?
something that I had for the records, or should I not?
If you would like to pass something up, that's fine, but we'll just put it in the file.
Okay.
If you want to just hand it down at the end of the row.
All right.
All right, thank you.
Oh, you got yours too? Okay. These are just, I think you might already have this, but just in case, that's the signatures that I collected. For the ones who don't want the store, and this is some most new signatures. for the store.
Thank you.
Thank you.
All right, the next two cases we're going to call together, 2017-386. 2017-386, 2423 Greenmount Avenue, Mohammed Chowdhury, and 2017-387, 2425 Greenmount Avenue, also Mohammed Chowdhury.
Good afternoon. My name is Mohammed Chowdhury, and concerning property 2425 Greenmount Avenue and 2423 Greenmount Avenue.
Okay, and Mr. Chowdhury, just for the record, we have those applications described respectively as to 2017 as 386, The application is to use the premises as motor vehicle repair garage to include body, paint, and tire shops and motor vehicle sales. And as to 2017 F387, we have the same description, that is to use the premises as motor vehicle repair garage to include body, paint, and tire shops and motor vehicle sales. Is that correct?
Yes.
All right. Sir, if you would raise your right hand to be sworn, please.
Do you swear or affirm under the penalties of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief?
I do.
All right. Do we have staff reports?
Yes, we have a letter dated November 3rd from the Greater Greenmount Community Association. They write that the association opposes the application for a zoning variance to use the above referenced property as a garage for motor vehicle service and repair to include body repair and paint and motor vehicle dealership. Though this appeal, our opposition is based on the zoning of the property, which is C1. We note that a C1 zone described as commercial cluster or pedestrian-oriented corridors of commercial uses that serve the immediate neighborhood ensures compatibility between neighboring residential and commercial uses. The proposed use is more appropriate for C4 zones, which are described as heavy commercial intended for areas of more intense commercial, including uses related to motor vehicles. The properties immediately to the south of 2423 and 2425 at 2413, 15, and 17 and 19 Greenmount Avenue are zoned C1 and are used for residential apartments. It is important for the continued viability of these residential properties that the requested use of 2423 and 2425 be not allowed. And then there's planning's report.
Thank you. Planning Department reviewed both of these applications, which essentially overlap in terms of the proposed uses and also the existing uses being non-conforming under the current C1 zoning. The department noted that there is C4 zoning immediately north of these properties, which would have allowed these proposed uses by right. However, that said, it's the department's analysis that what the applicant is proposing is to diversify existing non-conforming uses by adding additional non-conforming uses within the walls of the buildings that would contain them. Based upon that analysis, and noting that this property is in the East Baltimore Midway Urban Renewal Area, where the Urban Renewal Plan does not prohibit the proposed use, the department recommends that approval of the application, if granted, be subject to these conditions. There will be no parking, staging, or storing of vehicles on public rights-of-way. There will be no parking or storage of unlicensed vehicles on the property. All work must be performed indoors. All materials, parts, and equipment related to the use will be stored indoors. Any area used for temporary storing of vehicles will be adequately screened by an opaque fence or wall. And if a dumpster is used to collect waste and trash related to the use or uses, the dumpster will be placed either inside the existing building or within a masonry enclosure having a solid lockable wooden gate. Thank you.
All right, Mr. Chaudhry, are those conditions acceptable to you?
Which is recommended by the...
Those just stated by the planning department, yes.
Yes.
All right. Why don't you tell us about what you're proposing here, and if you also can address the current use or the use that you've made of the property since you've owned it.
Property 2425 Greenmount Avenue, Baltimore, Maryland, is already licensed mechanic shop. Existing mechanic shop is there, and they want paint booth there.
They want what? Paint booths?
Paint booth.
Okay.
And when I get a regional zoning in 2008, the zone board approved me for the paint booth, but somehow they did not install the zoning expired. Now they have funds available, they want to install the paint booth and body machine. So that's, which is 2425. But 2423 next door building, which is I totally renovate now. New roof, new bathroom, new electricity, new driveway, new 16-foot shutter gate, 16-foot wider shutter gate. So I spend a lot of money on it. But there is no other way. That's basically auto place, marketplace. If you go 25th Street, 25th and Greenmont, till Harvard Street, all there is a mechanic shops, body shops, paint booth, or tire shops. Nobody want to lease the property for houses because this is a warehouse. With my two property with the 2425, which is already existing, 2423, which is I develop now, is only for that purpose. And I know I have this all a record for Greenmont Avenue and that area for how many houses are abandoned, how many buildings are abandoned, how many crimes are there. There's around 6 homicide in 2017 on my street, Greenmont Avenue, between 1200 block to 25th block, 2500 block. 6 murder in 2017. And I still willing to upgrade the property, and it's good for the community, good for that neighborhood. So there's jobs come in and have more buildings open. I have this all information in this big file, all photographs on Greenmont Avenue, and if you want to see, this is all information in it.
Okay.
Murder history and the walking history and people's are house buildings, abandoned buildings. So everything I put in this file.
Okay. I see that you got a lot of information.
Yes.
In here. So, all right, so there's 2 properties here. For 2425 Greenmount Avenue.
Yes.
As I'm looking at this again, the proposals are slightly different. So as to 2425 Greenmount Avenue, I have the description as to add tire shop, body repair, and painting and motor vehicle dealership to within the existing garage for motor vehicle service and repair. So with the building that's at 2425, what's going on inside of there?
It is a 6,800 square foot building, around 16-foot high ceiling. It is in garage inside.
It's a
garage.
Garage, okay.
Yes.
And what do they do in there?
They do they fix cars, they sell tires, small scale, some tires, and that's all they do. But they want to paint booth.
Okay.
And they want to what's called a frame machine they can fix cars.
Okay, all right, so they want to do, so it sounds like their existing operation is maybe more of a Jiffy Lube, Pep Boys type of operation, changing, sort of minor car repair, car maintenance. And what they're looking to do is more major work.
No, they
body
already
work,
do major work on cars as a mechanical work. Mechanical work. They do all kind of mechanical work, but they want add because the profit margin, their employees and everything, rent is not sufficient to in one category. So they're looking to add other categories so they can manage their business properly.
Okay. All right. And I asked that because I guess with the change in the zoning code,
Yeah.
There's been a little bit more refinement in motor vehicle repairs.
Okay.
So the code now looks at major repair versus minor repair. One of the things that puts a operation into major repair is the inclusion of painting, in addition to body, frame, repair, straightening, that kind of stuff. Motor vehicle repair minor refers to more of the quick lube type operations.
Yeah.
The importance there being that for major repair requires a much larger lot size, requires a 20,000 square foot lot size for major repair, and requires half that lot size for minor repair. So in order to do what's being sought here is a major major motor vehicle service and repair. So that means that they'd need 20,000, well, you'd need 20,000 square feet. You're seeking an 80% variance. It's pretty large.
So they're not doing that kind of major things. It's a, you can say minor and little bit above minor, not major.
And I understand sort of your attempt to sort of minimize it. But the fact is that the code, once you add certain uses, the code, regardless of your concept of whether it's major or minor, the code says it's major. All right.
Okay.
So just by, for example, just by including painting along with it, it becomes major, which results in an enlargement of the required square footage. And I think as the planning department was indicated, there are close by locations. Did you say, Mr. French, it was the C4
Yes.
zoning district where that's much more permissive as to these types of uses? The intent of the code being that they want to squeeze out these locations from the C1 district into more the C4 district. You can make whatever you want of that policy choice there, but it's not really ours to make. That in and of itself doesn't mean it's not permitted. It just means that it's a rather large variance that's being sought.
Greenmount Avenue and 25th Street is a C1 zone. So they, like we talk about Greenmount Avenue, because I'm on Greenmount Avenue, it's more than 50% buildings are abandoned. Nobody there. So at least I bring a sufficient fund to upgrade the property and looking for to operate. It's good for the city, good for the neighborhood. Since I own these buildings, I paid almost more than $65,000 property tax to Baltimore City. So that's why I'm, because my tenant, if they cannot run business efficiently, profitably, so they're gonna leave and then I go to the bankrupt.
Mr. French, did the planning department have a position regarding the limitations imposed under 18302, expansion of use? Is 18302 says non-conforming use may not be expanded in any manner, nor may any structure be erected or expanded unless the use of the land and the structure are made to conform to the regulations of the district in which they are located.
The department's position was that the use of the property covers the whole property currently, the non-conforming use. Therefore, there is no expansion. It's a diversification of non-conforming uses from 2 or 1 into multiple or additional non-conforming uses. Therefore, we did not see it as an expansion of non-conforming use.
Okay.
The building 2423, it was empty. I mean, it was storage, but it's a very minimum income I generate from it. It's almost abandoned, but now I put it a whole 9 yard in. New roof, new bathroom, new office, new electricity, new driveway, new shutter door, new painting.
And that building was vacant before you did this?
Yes.
How long was it vacant?
I mean, it's a storage, kind of storage. Just somebody put a material in and take it and on. That's all.
And how long had you been using it for storage?
It's just many years. I bought this property 2008.
Which one is this? It's 23 or 25? That's 25. That's your 25.
And I worked with the code. I pull all permitters, electric permit, shutter permit, or wall permit, all required permit I pulled.
So you've been renting the building out for storage to other people, or using it for storage for yourself?
Oh, I was using myself.
Okay.
And now I'm using this 23, I'm sorry.
I'm talking about 23, 20, wait a minute, 24, 23.
Yeah, now I'm gonna use myself again. But I'm putting little more effort to generate money. I want to buy a car from Maryland because good buying here. And I want to, whatever minor repair, I repair it and sell to the Virginia or Pennsylvania is good sell price. Buying price is good in Maryland, sell price is good outside of Maryland, like Virginia or Pennsylvania. So that's my all plan is.
Buy low, sell high.
That's right.
I know. So on 24, 23, was that ever used as an auto repair?
No.
It was never used as that? Okay.
But they've been used for, before is auto store, auto parts store.
Okay. You know how long ago that was?
More than 8 years.
Okay.
Any other questions? Okay, thank you.
Thank you very much, I appreciate it.
Nope, one more, see?
I always wanted to say that.
So there are files you need?
I'm sorry?
The file?
No, you can, actually, yes, we are on the record. You can either make this part of the record, if you'd like to submit this, you can, or if you would like this back, you can have it back, either way.
So what is the benefit? I mean, if I,
We have the benefit of looking through it to the extent that we haven't covered it. Does anyone else want to review his materials? So actually, I guess you can have it back.
okay. Thank you, I appreciate it.
All right.
So I cover almost every corner of that area.
I can see it's very thorough.
Yeah.
Thank you.
Thank you, appreciate it.
All right. Okay, and now we're off the record. See, good. All right.
Decisions aren't on the record, correct?
I'm sorry? Yes. All right, which ones do we want to talk about?
I guess St. Paul. And I have, 24, 23 agreement. I'm okay with 24, 25. I don't see how we get there with 24, 23.
You might have it backwards.
Do I?
24, 23 is the one where they've already had the use.
Okay,
24,
then I got it.
25.
Yeah, okay, then I got it backwards. Okay.
Yeah, I agree. So I guess maybe we're starting with that one. I'm in the same place. I was hoping that there'd be some kind of relation, but
I tried.
yeah,
Yeah.
I mean, it is what it is.
Yeah, that's the city, his remedy is the city council. Because that building really is an auto,
Oh,
yeah, that's what it should be used for.
yes. I mean, I get it. They wanting to squeeze that out and see something else go in there, but I mean,
We can't do anything.
All right, that's those, St. Paul. I think that whatever the zoning card said in 63 and 64, that wasn't the use that was made of it in 71. And as Derek pointed out, to use a property as a single-family dwelling, you don't need to pull a certificate of occupancy. And so the, in fact, use of it was single-family house. And the testimony from, that, well, I guess the proffered testimony that Lee offered, well, I guess, no, she was sworn, was that the applicant changed the property when they bought it into apartments, without pulling any permits or anything like that. So the situation is sort of where he placed himself.
Yeah, I agree with you. My note to myself was the office use was abandoned.
Yes.
And it reverted back to a single family.
Yeah.
I want to know why Hopkins was studying ballistics.
Well, John Nash was doing whatever he was doing at Princeton.
Oh, there you go.
For Greenmount, I have for the property that was formerly used as a warehouse, but the current business and the adding the services to that business. Did we cover that already?
Yeah, what we said was that as to 24, 23, there's really not an issue with what's being sought.
Okay.
But as to 24, 25, let's see how we can establish that for the use that's being sought.
That's the one that would require the 80% variance.
Yeah.
Okay, yeah.
Well, I think
I'm there.
it might be required as to both, but there's no history of.
One was needed 20 and had 60?
60, yeah.
And, or 6, had 6, 64.
One was 66%, another one's 80.
Yeah.
Right. One was 10,000 and had 4,000.
Not exactly.
For the one on Eastern Avenue, 2017 402. I wanted to cut the hours, and I mean I see what's being sought there, but I just see it as like an opportunity to get wildly out of hand.
You don't sauce at 11 a.m.?
Yeah. I'm not sure if the application said it was the various. I don't know that the application restricted it as they did in the testimony. That that there's not that any live entertainment is without. There's no DJ. There are no bands. That the live entertainment is via programmed electronic devices. He did agree to the proposed hours, 8 to 1:30. And if he wants it 7 days a week, okay, I guess we can give him that with the cut in the hours. But 11 to, what was it, 11 to 2?
11 a.m.
7,
to 2.
yeah, to 2 a.m., 7 days a week seemed a little bit much. Other than that, just the conditions that from planning.
Any discussion on Falls Hill?
It's okay with it.
I was okay with it too. I think that the owner did much better presentation of it at the end, sort of going through the various different variances that were being sought. But I think that for me, it really comes down to the community wanted fewer number of units, but it's permissible density. So, okay, so he's permitted this amount of density, and then when you look at the the lot size variances, they were all very small, and I think that just reflected, okay, if this is the permitted density and you spread that out across the number of permitted units through the property, this is sort of what you wind up with. And everything else made sense, particularly with the lots having to be pushed back, and then also the allowance that they needed to make for the width of the road, et cetera. So I was fine with that. All right, any others? Okay. Let's start from the top. Ready, Derek? Yep. All right, 2017-367, 3009 St. Paul Street, M&O.
No.
Great.
2017-380, 1100 Falls Hill Drive, MES.
Yes.
Yes.
2017-386, 2423 Greenmount Avenue, I'm a,
It's 23.
yeah, let me just find the thing.
You got it, Nick.
Yes. Okay, as to,
3 is yes and 25 is no, I think.
yes, I think that's right. 2423 Greenmount Avenue, I'm a no.
Wait.
That's what I
23
said.
was yes.
Yes, that's right.
So I was correct.
Good, yes,
Okay.
yes, you were correct.
So, no, I'm a no.
I thought it was the other way around.
I think it is. Here's the way it draws out.
First page.
This is 23, this is
Yes.
25, this is what he was using as storage and wants to do his
Yes.
thing in now, and that's the one you're okay with.
No, I was okay with,
The one where the business, where the repair
Yeah,
business
that's 25.
currently operates.
That's
Yes.
25.
And that's the 80% variance.
Yes,
Which
yes,
is a
yes.
no.
yeah. Well, no, I'm a no as to here because there's no use that's going on there. So so with 2425, they are adding the use to the existing use that's being made at the property.
Right, which makes it major.
But it's not prohibited. For 2423, there's no use of it, so you're really like establishing it.
But this one's the one that required the 80% variance.
In the new
But
one.
it's not
Yeah,
the
yeah.
percentage of
And
variance
it's the
really
one
that was
we-
determinative for me.
Okay,
Well, yeah, that's true.
It's a pre-existing precinct.
Right.
I know.
Right.
But that's a big difference between what they have at 1,600 square feet and what the code says they were supposed to have at 20,000 square feet.
Yes.
True, but they're already doing major repairs in the space. They're just adding one more component to the major repair.
Well, they're one,
Under a proper permit.
Yeah.
You don't have to go along with it.
yeah, I'm gonna be a no. I'm 25.
As to,
We haven't got to
okay,
20. you
no, we
gone to
haven't.
25.
No, we're on 23. Where I'm a no. Frank, you're?
I'm a no.
Okay.
On 23?
Mhm.
No. Does this help? This one's 23 and this one's 25.
I'm a no on 23.
Yeah. I'm a no.
All right, 2017-387, 2425 Greenmount Avenue, I'm a yes.
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 Agreed.
No.
All right, 2017-390, 1607 Webster Street, was by consent. 2017-402, 2724 through 2726 Eastern Avenue. I'm a yes with the hours restricted to 8 till 1:30, and the, I guess the other restrictions agreed to on the record regarding types of live entertainment, et cetera.
Yes.
And in addition to the conditions offered by the planning department.
Yes.
Agreed.
Yes.
2017-403, 3138 Chestnut Avenue, I'm a yes.
Yes.
Agreed.
2017-406, 3642 Elm Avenue is by consent. 2017-407, 2500 East to Northern Parkway was by consent. 2017-410, 1821 through 1831 West Lafayette Avenue was a no-show and was dismissed. 2017-412, 1500 West Baltimore Street was postponed. In 2017-413, 2000 East Baltimore Street was postponed.
What's commonly known as head shops permissible in Baltimore City?
Is what?
What's commonly known as head shops permissible in Baltimore City? Selling of marijuana paraphernalia, bongs and bowls and
Yeah.
whatnot.
You wanna start one?
No, but but what, how do we know that they are permissible or are not? I'm just wondering what the art gallery and gift shop combination could be.
Oh,
You could have pictures of,
You can only charge paraphernalia, right, if you charge with the CDS, I think. So if you
Yes.
just have paraphernalia, you so, I don't know, but I would think that you could, yes, you could have a head shop as long as you weren't selling things that.
you could just have pictures and posters of Bob in the front